Someone make it make sense.
Probably a couple.
What is up, party squirrels? We are back for more Karen Reed. Was going to do this last night, but the internet was out on my street, and they said the outage was expected to last until noon today, but internet's here, so hopefully that remains to be the case, and we can go over all of these most recent filings, as well as the Vanity Fair article regarding the juror who is now going to be a part of the defense team for Karen Reed at the upcoming trial. Shout out to ABC's Docket. First here in the chat, who's here but working, love it. Who cares about work? This is more important. So we've got lots to go through here. And for those of you guys who are members, we had so much fun the other night on our members only live stream for Never Have I Ever. For anyone who wants to be, for anyone who wants to contribute a category for the next members only live stream, which will be the trivia night with the categories. I know I've mentioned it many times, but get your submissions in. I'm probably going to have to say by either tonight or tomorrow, so that way I can start compiling the questions. Of course, you don't have to. You can still participate in the trivia night, but those of you guys who want to submit a category that you think you will do best at, I will, of course, be doing an even number of questions for all of those categories, as well as additional categories that I'm going to be including. So that will be, and then we will be able to have that members only live stream next week. So get your questions in, guys, in the Discord. Go to the members only thread and you can submit those there. Shout out to Pure Duckery and shout out to Happy Annie. People are either at work or getting ready for work, but are listening. Love it, love it, love it. And of course, as always, for anybody who is on Replay Crew, we will always have timestamps that are very specific so that you can always find what you're looking for there. So, okay. First up, we have defendant's memorandum in opposition of Commonwealth's motion limited to exclude Michael Easter's testimony. All right, so the proffered expert testimony of Michael Easter is plainly admissible under Massachusetts standards for expert testimony and is relevant and admissible in furtherance of Ms. Reed's Bowdoin defense. The investigation conducted by the Canton Police Department and the Massachusetts State Police was deficient. What do you guys think? Was it deficient? And failed to conform with standard investigative policies and procedures. Defendant, therefore, has a right to present the expert testimony of Michael Easter, a retired and decorated agent with the FBI. Hang on, we have a thing for that. Do-do-do. You'd always just have this ready to go. I'll read that sentence again. Michael Easter, a retired and decorated agent with the FBI. The FBI! To testify regarding standard investigative policies and protocols and law enforcement's failure to adhere to those policies and protocols in this case. Argument. Okay, Massachusetts case law supports a defendant's right to call law enforcement experts in investigative procedures to advance a Bowdoin defense. The Supreme Judicial Court has made it clear that a defendant may introduce evidence that the police investigation was inadequate or unreliable. Pursuant to a Bowdoin defense, a defendant may introduce evidence regarding the police investigation in order to create an inference that the evidence at trial may be inadequate or unreliable because the police failed to conduct the scientific tests or to pursue leads that a reasonable police investigation would have conducted or investigated, and that these tests or investigation may have led to significant evidence of the defendant's guilt or innocence. Important thing there, right? Guilt or innocence, because if you're the state, right, or in this case, the Commonwealth, you should want to do a thorough investigation because what you would expect to find is evidence that would support the defendant's guilt. So I appreciate that it's guilt or innocence here because, again, it brings to light or sheds light on the fact that the Commonwealth or the state, right, should have motivation to do this properly. Indeed, a defendant has the right to base their defense on the failure of police to adequately to investigate a murder in order to raise the issue of reasonable doubt. In Commonwealth v. Bowdoin, the Supreme Judicial Court held that a judge's instruction for the jury to ignore testimony about the non-existence of certain tests and other evidence when deliberating constituted a reversible error. The SJC states The fact that certain tests were not conducted or certain police procedures not followed could raise reasonable doubt to the defendant's guilt in the minds of the jurors. The judge should not have removed this evidence from the jury's consideration, and in so doing, invaded the province of the jury to decide what inferences to draw from certain evidence. While Massachusetts courts have not been specifically presented with a challenge by the Commonwealth or a defendant regarding a defendant's right to present an expert on deviations from standard police policies and procedures in the Bowdoin context, courts have generally recognized a defendant's right to present this type of evidence and taken no issue with a defendant calling an expert to challenge the adequacy of a forensic investigation. For example, in Commonwealth v. Wood, the Supreme Judicial Court denied the defendant's request to set aside the verdict on the grounds that he was precluded from admitting evidence that law enforcement failed to investigate a third-party culprit, where there was no evidence suggesting the third party was in any way involved in the death. In doing so, however, the court reasoned that the issue of inadequate investigation was fairly before the jury because defense counsel was permitted to extensively cross-examine an officer about his investigation, argue in closing that the investigation was inadequate, and through the calling of its own expert, extensively challenge the adequacy of the forensic investigation conducted by the police. Now, here's what's important here. Remember in the hearing when Hank Breenan was like, oh, well, we're going to have to call all the officers back and have them explain why they did what they did. And I was like, this is ridiculous. You have an expert here and then you bring a rebuttal expert. That's why this is in bold and underlined, right? So in other words, what this is saying is that, yes, they can cross-examine the officers about their investigations. They can also argue in closing that the investigation was inadequate, but also bring an expert in to challenge the adequacy. Thus, the Supreme Judicial Court acknowledged a defendant's right to call an expert to challenge the adequacy of a forensic investigation. The issue presented here, i.e. calling an expert to testify regarding law enforcement's failure to conform with standard investigative policies and procedures is no different and must also be admissible. In Commonwealth v. Dyer, a defendant claimed ineffective assistance of counsel based on the counsel's failure to hire a forensic expert to testify regarding the crime scene investigator's failure to investigate certain gunpowder residue patterns. So they're saying basically that this was found to be ineffective assistance of counsel if you don't do this, right? So that's another important angle to look at here. Indeed, under the rationale articulated by the Supreme Judicial Court in Dyer, expert testimony regarding law enforcement's failure to follow certain standard protocols or procedures or to engage in necessary or appropriate testing is not only admissible, it would be ineffective for counsel not to present this evidence. Similarly, in Commonwealth v. Reynolds, this defendant sought to call a non-expert police officer to testify in support of his Bowdoin defense. And so they're just presenting other case law here. Under the Massachusetts Rules of Evidence and the relevant case law, where an expert is not testifying on scientific, technical, or medical matters, the Daubert-Lanigan standard and general acceptance tests are not required. Rather, courts are encouraged to exercise discretion as to whether particular testimony would help the jury understand information that is not within their common knowledge and to determine that the testimony presented is reliable. For soft sciences and other non-scientific, non-technical, and non-medical testimony, the court has broad discretion to determine testimonial reliability and may turn to Daubert-Lanigan for guidance, but may ultimately decide which factors may be applicable. So that's important, right? Because in the event that the Commonwealth wants the solution to be a Daubert-Lanigan hearing, they're saying, Judge, Judge Bev here, right? That's different here. And that is not necessarily going to be the avenue you have to take. Under this form of expert qualification and reliability assessment, police officers routinely testify as experts in Massachusetts. Police regularly testify about the nature of drug transactions. Okay, we don't need to read about drugs, not relevant here. While police may testify as experts, one of the court's primary concerns is blurring the line between specific testimony as a lay witness and more general testimony as an expert. Here, Mr. Easter is an expert in investigative procedure. He is a decorated agent with the FBI. The FBI! And is qualified by years of experience, well beyond the experience of the expert in Commonwealth v. Little, and his testimony about proper police procedure and as an investigation would surely aid lay persons on the jury in determining whether the investigation here was deficient. Given that he is only an expert witness, there would be no concern of blurring the line between his general testimony as an expert and specific testimony based on his investigation. And then we have number 2. Massachusetts Rule of Evidence 702 and Federal Rule of Evidence 702 are nearly identical, and thus federal law is instructive. But for one clause included, and I feel like we heard them argue this in the hearing, Federal Rule of Evidence 702 that is not included. And here they're making that distinction. Let's just go to this footnote here. Okay, so Massachusetts Rule of Evidence 702. A witness who is qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion or otherwise if A, the expert's scientific, technical, or other specialized knowledge will help the trier of fact to understand the evidence or to determine a fact in issue. B, the testimony is based on sufficient facts or data. C, the testimony is the product of reliable principles and methods. D, the expert has reliably applied the principles and methods to the facts of the case. Now here's the federal rule. A witness who is qualified by an expert by knowledge, skill, experience, training, or education may testify in the form of opinion or otherwise if the proponent demonstrates to the court that it is more likely than not that. And then A, B, C, and D are pretty much the same. So they put it in bold, the difference here between the Massachusetts rule and the federal rule. And here's the difference. And here's where I think this could be a problem considering this judge, right? The difference here, right? The Massachusetts rule is missing the part that is in bold here, the more likely than not. If the proponent demonstrates to the court that it is more likely than not. And that part is missing from the Massachusetts rule, which those of us who've been following this case and how things go in Massachusetts probably aren't all that surprised by that. And then it even says here, the principal difference between the federal rules and the Massachusetts approach to reliability is that in Massachusetts, the proponent of expert testimony may establish reliability by simply demonstrating that the underlying principles or methodologies are generally accepted by the relevant scientific community. Okay, and then they're basically just, there's the footnotes there that we just read. It's especially useful and persuasive in numerous instances under the Federal Rules of Evidence 702. Law enforcement witnesses have been deemed experts in investigation and procedure. In U.S. v. Polson, the U.S. District Court for the Southern District of Ohio held that the defense may introduce expert testimony by a former FBI agent on the adequacy of the government's investigation. And again, a lot of this is they're just providing all this case law. Because remember, Judge Bev was like, I've never heard of this. And I'm like, you've got to be kidding me. I've heard of this. I've seen this in many cases. It happens all the time. That was crazy. And it was even crazier when she was like, are there any ways to determine that the person is, are there any organizations? Is there anything? And I'm like, wait, what? What about NAFTA? What about INAB? Or ANAB rather, I think it is. Like, it's crazy that she's like, I'm like, is she pretending she's never heard of this? Like, this is insane. So he's providing lots of case law here, I guess, especially because Judge Bev claimed to be completely unfamiliar with this. Of course, which is funny because Bowden is a Massachusetts case. But anyway, in Thomas v. Lambert, a former Michigan State police officer who also worked in the Air Force Office of Special Investigations and founded in Rand an investigative group was deemed an expert in proper techniques and reasonability of police investigation. And then they've got a footnote from the case law there. The court further noted, okay, again, this is just more case law. Here, Michael Easter's proffered expert testimony clearly satisfies all the elements set forth in Evidence Code Section 702. Indeed, his specialized knowledge will assist the jury in understanding inter alia law enforcement's failure to follow standard policies and protocols regarding crime scene management, chain of custody, handling of evidence, managing a chronological record, and timely and accurate reporting in connection with its investigation. Shout out to official. Welcome, welcome. Right? Pure Duckery says, I'm being serious. Does Bev have early onset dementia? It could be a possible explanation for sure. Can't rule that out. Law enforcement failures in this case are well documented and in violation of the stated policies and procedures set forth in the Massachusetts State Policy and Procedure Guide. His proffered testimony is the product of reliable principles and methods which are based on his years of experience as a decorated agent with the FBI and the stated policies of the Massachusetts State Police. Finally, his opinion reflects a reliable application of the facts of this case, namely information obtained directly from the Commonwealth and the police reports and logs associated with this case and the stated policies of the Massachusetts State Police. Thus, like the expert in Polson, Mr. Easter uses years of experience to testify. Yeah, I mean, to me, this just goes without saying. Finally, the Commonwealth's suggestion that the examination or evaluation of procedures and protocols would be speculative, is belied by Mr. Michael Easter's report, which repeatedly references the policies set forth in the Massachusetts State Police Policy and Procedure Guide. While there may be variation between different officers' investigation styles, all law enforcement agencies have standards to ensure competent, adequate, and ethical investigations. The suggestion that any assessment of the investigation would be simply a subjective opinion as opposed to objective analysis based on professional standards and best practices is insulting to officers that spend years developing expertise in the area of investigation. Welcome, James. Excellent. Happy to see you. And now we're still in the argument portion. We're on Roman numeral number 3. The Commonwealth's authority regarding second guessing law enforcement officers is inopposite. The Commonwealth cited 2 cases to suggest that expert testimony about investigative procedure would amount to second guessing law enforcement officers. However, these cases are not applicable. Both cases dealt with in-field arrests where officers had moments to determine the legality of their arrest. So what they're saying is their case law sucks, basically. Here, there is no allegations that any steps police officers took were based on fear of personal safety or immediate time pressure. Rather, the question is whether officers followed proper procedure and protocol in instances when they had ample time to make decisions. Yeah, like, for example, the red Solo cups. While certainly officers in this case may have faced pressure based on weather and other considerations, this is distinct from officers making heat-of-the-moment decisions in a split second. And then here we go with Roman numeral number 4. The Commonwealth is free to present rebuttal testimony. Yep, do it. You guys remember that moment? Here, hold on. I've got a clip.
Mr. Breenan said, what if I called in a Massachusetts state police officer to say that this was the best investigation ever? I have 2 words. Do it.
All right, there we go, guys. During oral arguments, the Commonwealth repeatedly implied that admitting Mr. Easter's testimony would create some sort of slippery slope. The Commonwealth suggested that if Mr. Easter's testimony is admitted, that the Commonwealth could then bring in their own expert to rebut Mr. Easter's testimony. That is true. The Commonwealth is permitted to rebut a Bowden defense, specifically by presenting evidence as to why the police did not follow the line of investigation suggested by the defendant. What the Commonwealth suggests would be an impractical or impermissible consequence is actually an entirely expected result of the Bowden defense and is supported by case law. Conclusion: Mr. Easter's expert testimony is both relevant and admissible in support of a Bowden defense and therefore should be admitted. For the above reasons, Ms. Reed respectfully requests that this honorable court allow Mr. Easter's expert testimony to be presented to the jury. Bam. Next up, we've got a decision here. So, memorandum of decision and order on defendant's motion to exclude the purported expert testimony of Dr. Aizik Wolf, not ARCCA Wolf, different Wolf. We got more than one Wolf, and request for a Daubert-Lanigan hearing. So we're not even going to get a Daubert-Lanigan hearing on this, right? After hearing and review of the pleadings, court finds that the Commonwealth has satisfied, shocker, right? Of course, it's disgusting, the foundational requirements set forth in Daubert v. Merrill Doe Pharmaceuticals and Commonwealth v. Lanigan. So Daubert-Lanigan, right? The proposed witness is qualified as an expert to testify that the head injuries sustained by the victim in this matter are consistent with falling backwards and striking his head on the frozen ground. And if you're wondering, is this the hard as a rock dude? Don't worry, we'll get to him. This is the different dude. Dr. Wolf has the requisite education, training, experience, and familiarity with the subject matter of the testimony to qualify him as an expert. He's a board-certified neurosurgeon with 35 years of experience. He graduated from Yale Medical School and has held numerous faculty positions at various university hospitals for the last 3 decades. None of that is relevant. That's not how you... We know what the test is and its methodology, right? He's a founder and the medical director of the Miami Neuroscience Center. He's authored many publications in his field of expertise, including several peer-reviewed articles and numerous book chapters and journal articles related to head injuries. Thus, it's clear that Dr. Wolf is adequately qualified to offer his expertise. I mean, if this was literally how she should be, if this is how she's assessing these experts, right? Is like, look, are they qualified? Did they do this stuff? Are they like, then look at everything that has happened in this case. I mean, I don't need to tell you guys, right? But like, look at, for like the ARCCA dudes and for oh my God, why am I blanking on her name? Dr. Russell, right? I mean, it's just, it's offensive and it's sad. The double standard of it all. The Commonwealth has shown that the methodology or underlying expert testimony is sufficiently reliable to be presented for the jury's consideration. As noted, in addition to Dr. Wolf's many years of experience treating head injuries, he's authored numerous publications. So she's not supporting how the methodology is there. She's saying that the methodology was sufficient, but she's not saying how that happened, right? Instead, what is she doing? She's going back to his CV, basically. Numerous publications, Dude. The treatment and management of brain injuries and specifically fractures of the clivus. Based on his experience in published literature, his report adequately explains the connection between the force needed to incur specific skull fractures, the skull fractures incurred by the victim in this case, and the physical consequences resulting from such injuries. Therefore, his proposed testimony that the victim's injuries were consistent with falling backwards and striking his head on the frozen ground has a scientific basis and reliability needed to be. And this is, I mean, it was tough. It's hard to keep them all straight because there's so many, but I believe this was the one who was basing a lot of his opinions on the witness testimony. I'm pretty sure that was this dude. And she doesn't even address that, of course, which is insane. James is eating some breakfast. Excellent. Let us know what you're having. For the foregoing reasons, the defendant's motion to exclude the purported expert testimony of Commonwealth's proffered witness and request for a Daubert Lanigan hearing is denied. All right. Next, we have another decision from Judge Bev here. So this is a memorandum of decision order on Commonwealth's motion for buffer zone and order prohibiting signs or clothing in favor of either party or law enforcement. Prior to the defendant's first trial on April 4th, 2024, this court issued an order establishing a buffer zone around the Norfolk Superior Courthouse, prohibiting any individual from demonstrating in any manner within 200 feet of the courthouse complex and from wearing any clothing or insignia related to the courthouse during trial. The Commonwealth now moves for the court to reestablish the buffer zone for the defendant's upcoming second trial and modify the previous order by extending it to include area encompassed within Bates Court, Bullard Street, Ames Street, and Court Street. Shout out to Meg P, who's driving. Drive safely. Shout out to Miss Q. Welcome, welcome. And then there's a footnote here. During an argument on the motion, the Commonwealth withdrew its request for a second modification to the April 4th, 2024 order. To ensure the defendant's right to a fair trial, the court may restrict protected speech so long as the restrictions do not, quote, burden substantially more speech than is necessary to further the government's legitimate interests. For the same reasons that compelled the court to establish a buffer zone in the first trial, it is necessary to establish a buffer zone for the second trial to ensure the defendant's right to a fair trial. Okay, so the case continues to garner significant public interest. When the matter is in court, individuals line the sidewalks around the courthouse loudly, chanting and voicing their opinions about witnesses, attorneys, and the strength of the Commonwealth's case. They display matters which may be in evidence during the trial or share their viewpoints as to the guilt or innocence of the defendant on their clothing or on signage. If prospective jurors are exposed to the protesters and messages displayed on signs or otherwise, particularly before this court has an opportunity to instruct jurors about their obligations with regard to remaining fair and unbiased, there is a substantial risk that the defendant's right to a fair trial will be jeopardized. The risk extends to during trial where jurors and witnesses have no choice but to be exposed daily to the messages and the viewpoints of the protesters when entering and leaving the courthouse or sitting in the courtroom or jury room. Oh, did it? I'll have to take a look. Thank you for letting me know, Happy Annie. I did check. I didn't see anything, but it might have happened after I checked. So the buffer zone is necessary to prevent jurors from outside influence and to prevent interruptions and distractions during trial. It is therefore ordered that no individual may demonstrate in any manner, including carrying signs or placards within 200 feet of the courthouse complex during the trial in this case. So she's extending the buffer zone, right? This complex includes the building and then the registry of deeds, and then they're extending it Bates Court, Bullard Street, basically. There you go. It is further ordered that no individuals will be permitted to wear any buttons, photographs, clothing, or insignia relating to the case pending against the defendant or relating to any trial participant in the courthouse during trial. Law enforcement officers who are testifying or are members of the audience are permitted from wearing their department-issued uniforms or police emblems in the courthouse. Interesting. So law enforcement officers who are testifying. I can't remember, y'all. Do y'all remember when in the first trial, when law enforcement testified, were they wearing their uniforms? I feel like they did. Some of them anyway. Some of them did. Do you guys remember? I think some of them did. Which is typical. Usually in trials, some law enforcement officers will wear their uniform, some won't. But this is interesting, saying that they're prohibited from wearing it, which is interesting. Okay, so this is the about the sidebars, right? She wanted to be able to wear, Karen wanted to be able to wear like an earpiece. So this is the motion, the defense motion. A criminal defendant is entitled to a trial by an impartial jury. Yes, we know. Per Massachusetts Superior Court Rule 6, The trial judge in each case has discretion to determine a procedure for examining and selecting jurors designed to maintain juror privacy and dignity, identify explicit and implicit bias, and foster efficiency in the session. A defendant's use of headphones at counsel table to participate in cyber conferences, including juror voir dire, is an efficient way to ensure participation in all critical stages, mitigate concerns that jurors will not feel comfortable answering questions honestly and openly in the presence of the defendant, and eliminate the risk of prejudice to the defendant. So I think this is a good point, right? What they're saying, so basically, of course, she has the right, it's not in question, right? That she has the right to go up for sidebar, right? During the trial, of course, but also during voir dire. I think that this, what they're saying here, I think this has more to do with voir dire and wanting to wear the headpiece or whatever they're calling it. I guess they're calling it headpiece. And here's the thing, headphones, right? So because the thing is this, right? If the jurors during voir dire, like, okay, basically they might be less likely to, if they bring jurors, for example, to do individual voir dire and they bring them, to sidebar, like, or they're discussing it, they might not answer as honestly if they know she's listening, right? And the other thing is every time that she would get up to go to sidebar, and this is true for even during the trial, right? They could be judging the way she walks, the way she looks, that type of thing. And so I think it's actually really valid, right, to be able to wear the headphones. And, the thing is Judge Bev was like, oh, it's going to be so, like her what Judge Bev said during the hearing was crazy. She was like, made it seem like it'd be a really big deal to get headphones. Like that, the technology is just not there. And it's like, what the fuck? Don't tell me how, literally how. Tell me why. Oh, Pure Duckery says it. Okay, interesting. Yeah, that's what I was trying to. I was thinking to myself, I'm like, I feel like some of them wore uniforms, but maybe it was the first responders, like the EMTs. Maybe that's what I'm thinking. So, okay, Ms. Reed has the right to be present, of course, right? Again, this goes without saying. Her right to be present is not going to be an issue here, so I'm not going to even read all this. Like, we know she has the right to be present. No one's going to disagree with that. Ms. Reed's meaningful participation in voir dire is necessary for a right to a trial by an impartial jury. Again, she has what they really need to, in my opinion, what they really need to be focusing on here is the headphones versus going up in person. Because Judge Bev's not going to say she doesn't have the right to be there, right? She has the right to be there. They need to focus on why headphones versus going up to the bench, right? Let's see if they get there. I don't know. I don't know if they're going to focus on that as much as they should. Ms. Reed is a member of the community in which she will be tried and might be sensitive to particular local prejudices, which her attorneys may not readily identify. Again, they're noting why her participation is important. No one's going to say it's not. It'd be improper to deny her the privilege of being present for cyber conferences. Again, I don't think that's the issue. They need to be focusing on the headphones, my opinion. Ms. Reed respectfully requests this court to afford her the chance to be present through the use of headphones at counsel table to enable her presence and secure her right. Yeah, they could focus a lot more again on why the headphones, and maybe they're not because there's not a lot of supporting case law, but they could still be arguing it. Judge Bev will probably say no, even if there is case law, but still. The trial judge in each case has discretion to determine a procedure for examining and selecting jurors to maintain juror privacy and dignity, identify explicit and implicit jury or implicit bias, and foster efficiency in the session. And the other thing is this. I really feel like the other thing they could focus on in terms of winning Judge Bev over on this one is the efficiency part, right? Because if it's going to be clunkier for Karen to go up to, sidebar every time and take more time, or it's just going to be more crowded and it's going to take longer, I think your winning argument here for Judge Bev is getting her right out on time at the end of the day, right? Right on the dot, 4:00 on the dot, right? Speed it up. She wants this trial done and over with. So I think that maybe the efficiency would have been perhaps the best angle here, that it would save time. It would save time, right? That's what Judge Bev cares about. Give her the headphones, it'll save time. Anyway. Conclusion, granting, right, her health issues. That's a great point. Yep. Okay. Pure Duckery is weighing in saying that, yeah, the EMTs were in uniform. Yeah. I think they were. Good morning, Candace. Happy to see you. So conclusion, granting Ms. Reed audio access 2 sidebar conferences at counsel table during voir dire is within this court's discretion, will allow her to meaningfully participate in identifying implicit and explicit bias among potential jurors. Additionally, limiting the number of individuals crowding the bench. There we go. Like this is focus on this. Crowding the bench, taking more time. That's your angle here, right? For Judge Bev. Crowding the bench during sidebar conferences will foster efficiency during the voir dire process. Ms. Reed's meaningful participation in the voir dire process can be facilitated by the use of headphones at counsel table. Avoiding overcrowding of the cyber conferences is an important logistical consideration for both efficiency purposes. They should have put that in bold, in my opinion, and assuring jurors feel most comfortable answering honestly. And that was something I just pointed out too earlier, right? I was like, because you don't want them to answer differently because they're like, oh, the defendant can hear what I'm saying. You know what I mean? On to the next one, guys. All right, we have the Commonwealth's notice of discovery. So they've been provided to the defense. So we've got a copy of it's crazy, right? Because like 5 days until jury selection starts and they're just turning more stuff over. Copy of transcript of the defendant's interview with Ted Daniels, part 2. Copy of transcript of full interview with William Reed and Janet Reed with Ted Daniels. Copy of emails to Special Assistant District Attorney Hank Breenan. Copy of voicemails to Special Assistant, we'll just say Breenan. I'm not going to read that every time. Copy of voicemails to the Lollybird. Copy of final report by Attorney Stephen Sack. I don't know who that is. Is that maybe that could be the Taint Attorney? Copy of transcript of the defendant's ID. Oh, the new docuseries, right? That's the new docuseries there. Copy of transcript of the defendant's ID. Again, more from the same new docuseries. And again, more. And then, updated PowerPoint by Judd Welcher. Okay. That was the dog trainer guy. Remember how he was supposed to update the PowerPoint? So it says updated PowerPoint. Now, that wasn't the only one. I believe they also had another one they needed to update a PowerPoint for. Do you guys remember? I feel like there was another expert for that because that came up in the hearing. But anyway, they have this updated one by Dr. Judson Welcher here. Yeah. Taint. Yes, Taint Attorney. Yeah. If anyone's unclear of what a Taint Attorney is, let me know and I will tell you guys what that is. But it is, that's a thing. Again, I was also shocked when we were watching kind of recently Murdoch, and in his second interview with law enforcement, he didn't know what a Taint Attorney was. That blew my mind because he is an attorney. I'm like, how do you not know what a Taint Attorney is when you're an attorney? Tell me why. So next up, we're going to pull this one up. We've got more, but wait, there's more. Okay, I just have to unshare, reshare. Okay, Miss Q does not know what a taint. Okay, good. I will tell you guys. So Taint Attorney. Okay, so whenever you're dealing with, oh wait, I shared the whole thing. I'm an idiot. Whenever you're dealing with attorney-client privilege information, or potentially, I should say, even if it's potentially, okay? Then if that needs to be, like, I'll just use the example from Murdoch, right? So when they were doing like the Celebrate extraction on his phone, right? Because he's an attorney, right? So there's attorney-client communications, right? On his phone, whether it be through text messages, through emails, same thing with a computer, right? So in other words, they can't have all of that discovery just turned over the way it normally would, right? Because there's attorney-client privilege information. So what they have to do is bring in a taint attorney, which is a separate attorney, a third party who has nothing to do with any of it. And their job is literally just to go, and they have nothing to do with the case. And they have one job. Their job is to look at the discovery and to determine, is this privileged? And if it is, it gets redacted or it gets pulled out. So that's not turned over to the prosecution or to whatever party it is. Because again, it could be a civil case, right? So same thing here, where because of the whole thing with the communications between, I mean, I guess in this case, so Judge Bev did deny him getting those text messages, right? But it could be that, so maybe that's so okay. The thing is that I haven't seen that new documentary, right? So I don't know as far as the video footage from the documentary and all that, like that is getting turned over. So I guess it could be that there's discussions on there. I don't really know. That could be there, but let's just say that had Judge Bev turned out, said, okay, you can have the text messages, right? They would have had a taint attorney potentially go through. Well, they should have. Again, what the Commonwealth was arguing was that none of it was privileged, but this would have, I think this has come up in this case anyway, even previously, where yeah, like all the communications that Karen's had with Mr. Unetti, like for example, when they did her Celebrate extraction, like the first time, right? They did have somebody, they would have had a taint attorney redact and pull out those communications with Mr. Unetti. And in fact, that's what the Commonwealth was asking for, was that redacted material. That was attorney-client privilege. And they were asking for that, and that was denied. So hopefully that makes sense. So yeah, it's just basically someone who's like, is this privileged? You know, whether it's the defendant and their attorney, or like again in Alex Murdaugh, for that example, it would have been him with his own clients because he was an attorney, right? So anything that is privileged gets pulled out. So they have to bring somebody else in. That's what they're called. They're called a taint attorney. So so what we're looking at here, guys, you're very welcome. So what we're looking at here is those of you guys who were here on a recent, I think it was the most recent Karen Read live stream, we were reading over the the jury questionnaire, and some of you guys in the chat were offering alternative jury questions. It really started with DSN. Shout out to DSN, but also we had Fender weighing in, we had Meg P weighing in, and I said, I'm going to save these and I'm going to compile another one with y'all's questions. And I made it look, in fact, I was able to use this. I mean, you can see it, right? It says 623, right? I was able to take the actual real one and then change the questions so that it looks exactly the same with the font and everything, right? And again, 623. So this is the updated one. Now, I will say what's really funny, I've never used Reddit or anything like that, but that is where a lot of the filings are. That is where a lot of the filings are posted for this case, where you can get them. And so, you know, I never have posted anything. I just have gone there sometimes for the filings, but there's like the Justice for Karen Read or whatever is where they have a lot of that. And so I will just say, for any of you guys who go there on Reddit or whatever, you will see this. I actually made an account. It's just like my Google account, but I like made an account and posted it because I was like, people are going to love this. And, you know, people are like, this is great. Da, da. It's getting all those, like, people can upvote or whatever it's called and like comment. And anyway, so you will probably see this actually if you go to that Reddit page. And people are like, this is hilarious. And so anyway, but you guys get all the credit for that because these were not my ideas. Happy Ganny is asking if anyone saw the hearing. So the hearing was related to the Turtle Boy, right? It was with the other judge. I know it was happening. I did not see it. I was actually watching the Shannon Gardner hearing, which we will cover probably later today because they were happening at the same time. We'll probably cover that later today. I will say that Shannon Gardner hearing from today is fire. Not only is it complete ineptitude with technology that is really hilarious, there's probably more opportunities for that's what she said than I've ever heard in a hearing or anything in court. Like, it's just insane. So many, over and over again. And literally Judge Kite even says something like, she says something, it's almost like hard as a rock. She says like rock solid. And I'm like, oh my God, I'm going to lose my mind. It is amazing. So, and I think there were some other things that were really noteworthy about that as well. Oh, I know what it was. I remember. Ooh, okay. So the defense mentioned their tech expert because they're talking about the technology and all that. And they said Mr. Green. Now, here's the thing. They didn't say the first name. So jury's still out on that, but it might be the same Mr. Green as in Richard Green for Karen Read. It might be the same. We don't know. I looked into it, couldn't find that out yet. We hadn't heard his name mentioned yet in that case, but they mentioned Mr. Green and he's their defense expert. And so that's one thing too, that it might be the same. We don't know yet. Okay. Thank you, Need Some Z's, and also welcome back. I know. Yeah. So again, because I was going to go live last night, my internet was down, and it was they initially said, guys, it was going to be down until 12 p.m. today, but it was back this morning. So I was like, all right, well, we're going to go ahead and I have internet, so we're going to go live again. Breenan tried to go to, was he flying too close to the sun? The judge shut him down. Worth watching. Okay. Well, we can totally watch that. I don't think it was very long. We can totally watch that as well, for sure. So freaking Breenan. So yeah. Right. Okay, so let's take a look at this courtesy of y'all, right? And again, you guys will see this if you go to the Reddit for Justice for Karen Reed one, you'll see this on there. I don't know if it counts as trending, but I'm just happy I was able to post it because I've never used Reddit as like a poster, and like I don't really know much about how that works, and I didn't even know if it would be allowed. I just don't know the rules, and I just didn't know what would happen, but like it all worked out is basically what I'm saying. So okay, question number 1: are you a McAlbert? Question number 2: have you ever answered a butt dial? Question number 3: do you generally drive through a military base to destroy your old phone when you are upgrade eligible? Question number 4: have you ever eaten a PB&J in the backseat while being brought home by a drunk driver? Question number 5: are a piece missing and smashed to bits logically equivalent to you? Question number 6: when gathering evidence, should party favors and lawn equipment ever be used? Question number 7: would you like to sit at a bar or at a high top? At the bar or at a high top? Question number 8: do you have a problem with people wearing shoes in the house? Question number 9: when publishing a lollipop video, is it always correct to flip it and reverse it? Shout out to Missy Elliott there as well. Question number 10. This was great because this was brilliant on DSN's part because he took this directly out of the actual juror questionnaire where they had like sad and mad. So it was like Mothers Against Drunk Driving, and I forget which one sad was, but basically I was like, that is sad and mad, right? Or the names of those organizations. So are you a member of TOD, Troopers Okay with Drunk Driving, or COD, Canton Cops Okay with Drunk Driving? Can you tell the difference between dog bites and injuries caused by a triple pirouette following an automobile strike? Thank you for James is putting DSN's command in the chat. Awesome. Love it. Are you okay with a little police corruption, assuming they really believe that she did it? Who, if anyone, was driving the ambulance? And then the last one here: have you ever spent more than one night at Bev's Cape House? It's a good one. And then let me see here. We also have, tell me why, James. I have to say that I'm not the first person to do that. I'm going to have to reshare this. I'm not the first person to do that. I will just say that every now and again, and I don't even know if it was recently, but every now and again, EDB would do that. And I loved freaking, I don't even remember, was that NSYNC or Backstreet Boys? But anyway, as a kid, you know? And but literally ever since she started doing that, I've been doing that in my head. And so now I'm just doing it out loud because it's amazing. Definitely an earworm. Freaking love it though. All right, guys, hard as a rock. Hold on.
Hard as a rock, freeze thaw effects on penetrometer resistance. You know, his head's as hard as a rock.
Is coming in. It is coming in. That's what she said. Hard as a rock is coming in. Did you guys notice that on the thumbnail? I mean, you might have to be particularly in the gutter to have just understood what I meant by that. But if you look at the thumbnail, it says hard as a rock is coming in. I hope somebody, before they hear me say that, gets that. That will make my day. I hope somebody's mind, I'm sure it will happen, somebody's mind is in the gutter enough to where they're like, oh my God. And I just wish, dude, it's where the fuck is Twiz and like Heather. Anyway, I'm going to do the command in the chat here as is warranted. We need more of these. We need one. I mean, it's just amazing. Pure Ducker will be back. Excellent. I mean, you know. So hard as a rock is coming in. And what is funny, right, is they are going to be arguing, right, the Commonwealth, right, that the ground was hard as a rock and caused the blunt force trauma. So that hard as a rock, if you just, the synopsis there, hard as a rock caused the blunt force trauma. And that's like literally where this whole joke came from, because on accident, when I was texting Twiz one time, I was doing voice to text and I said heinous murder, and in my phone put penis murder. And that's where this whole joke came. This is where this all originated, right? And then we were like, oh my God, penis murders. And then we were like, blunt force trauma. And that's how the whole thing started. And now we have actually literally it happening. Like, it's amazing. So the commands, so you can find the commands here. There's a lot of them, but I'm glad I made your morning happy, Annie. That's awesome. Yeah. Hard as a rock is coming in. Hard as a rock caused the blunt force trauma. It's just all of the things. Just safety first, guys. I should have put a warning. Don't be drinking or eating or driving while you're listening to this. All right, guys. Memorandum of decision and order on defendant's motion to exclude certain testimony of Commonwealth witness Robert Gilman in the alternative Robert Lanigan hearing. All right. There appears to be no dispute that the Commonwealth's proffered expert in meteorology, Robert Gilman, satisfies. Oh my God. I can't even, I'm not going to get through this. You guys, Judge Bev is satisfied. Judge Bev is satisfied. Oh my God. Help. Judge Bev. You know, because it was really clear that this was silly, right? And we all had fun laughing at it. But I have to wonder, is she satisfied because it's as hard as a rock? Is that what it came down to for her? Maybe. Maybe that's why she's so cranky. Oh my God. Maybe that's why she's so cranky all the time. She's like, I need to be satisfied and I need it hard as a rock. I'm going to lose it. Guys. Who would have thought that trials and fucking just the court filings, right, could be like maybe requiring some sort of rating? So she's satisfied now that we've got hard as a rock coming in. All right, excellent. Satisfies the foundational requirements set forth in the Robert Lanigan, and therefore may testify as to the weather conditions. However, the defendant seeks to preclude Gilman from testifying as to the hardness of the ground resulting from the weather conditions, to the extent that the Commonwealth seeks to elicit such evidence that the defendant believes is beyond the witness's field of expertise. Defense counsel can object to the line of questioning. So they can object to it, but, you know, if at trial, if the proper foundation for such evidence is not established, they can object. So basically it's coming in. That's just, you know, and if they object to it, she's going to say it's fine. She's no rule. She wants the hard as a rock to come in. That's clear. So the defendant's motion is denied. I'll be honest, while like legally this is not fair and not right and not good. See, my brain is so much thinking about the hard as a rock that I can't come up with better words than that. But this is like a trooper Paul for me. This is like a trooper Paul for me, where even though it's not in the interest of justice, right? Just like with trooper Paul, just like how I want trooper Paul to testify again, I'm glad this is happening. I'm glad this is happening because it's in my mind, like this is going to look so dumb anyway, but this will give us so much great testimony to laugh at and make jokes with. And it'll be moments that will live in infamy, right? Like we've had already from these trials and from the hearings, from other trials, it'll provide so much great content to laugh at until the end of time. So next up, unshare, reshare. So next up, we have Franks is here. Excellent. You missed a bunch of dirty jokes, Franks. Seriously, you will die. Go back about 2 or 3 minutes because it gets really dirty. 2, 3, or maybe 4 minutes. Go back a couple minutes, Franks. You will be glad you did. And then you can jump to where we are. Seriously. Franks will appreciate what I was just saying about the thumbnail. And the thumbnail saying hard as a rock is coming in, and then it all got dirtier from there. Yeah. Yeah. Yay! We love it. We love it. So this is, you guys, I'm sure have seen this already, but right. So this is Victoria George. I waited for nearly a year after the mistrial, hoping the court system would work as intended to remedy some of the wrongs in this case. I don't know how to get rid of this, unfortunately, so it's just there. Can I like not even read it? Is that how that works? Can I not even read it? Is that it? Is that it? Is that all? That's what she said? Listen to the story? I don't know. What does that do?
Exclusive. A juror from Karen Reed's first murder trial has joined.
Well, I guess we have to listen to it, which is annoying. I guess that's what we have to do. Okay.
Her defense team. In her only interview, Victoria George told VF, quote, "I waited for nearly a year after the mistrial, hoping the court system would work as intended to remedy some of the wrong."
So it sounds like she's literally reading what the printed version says. So I guess that's fine, right? Because I wanted to read it, but apparently you have to sign up for Vanity Fair, and I'm not doing that.
Wrongs in this case.
Carla.
By Julie Miller. This is a computer-generated narration.
Oh,
Inconsistencies
perfect.
in pronunciation and tone may occur. When Victoria
Oh my God, this is even better. This is even better than me reading it. It's computer generated. I hope that it fucks up and we can laugh at it.
Rafi George got the jury summons for the first Karen Reed murder trial outside of Boston in 2024. She didn't balk. A Princeton graduate who grew up obsessed with the Supreme Court, interned with a federal judge, and got her JD from Northeastern University School of Law in Boston. George says she feels a civic obligation to participate in the oft-dreaded enlistment. By the time she turned 34 last year, the employment lawyer had already served on 2 prior juries and acted as a foreperson. George had heard about Reed. The Massachusetts woman was all over Boston media as the prime suspect in the mysterious 2022 death of her Boston police officer boyfriend, John O'Keefe. Norfolk County District Attorney Michael Morrissey charged the then 42-year-old equity analyst with second-degree murder, manslaughter, while operating under the influence of alcohol and leaving the scene of a personal injury or death. Prosecutors alleged that, in a drunken rage, she had fatally backed her SUV into O'Keefe and left him to die in a blizzard. As Reed told Vanity Fair last year in a 2-part feature, she believed that she was being framed as part of a cover-up involving Morrissey and Massachusetts State Police Detective Michael Proctor. George, who joined Reed's legal team on Wednesday, was too busy caring for her 2 small children and grieving her mother, who died in 2023, to pay much attention, and was therefore qualified as a juror. Quote, "I was able to be a juror because I believed that the state court system was going to give her a fair trial," she told
Reports are
VF
good
weeks
on this.
before she joined the team. "I've been trying to continue to believe in justice for a while." George is a conscientious rule follower. Once during the trial, after she drove past a free Karen Reed billboard outside Gillette Stadium, she told Norfolk County Superior Court Judge Beverly Canone to make sure she was on the up and up.
Right,
The court assured her she was. During 9 weeks of trial, she says that she and other jurors stretched conversation limits to avoid talk of the case, which could not begin until deliberations. When another fellow juror began to openly criticize Reed before deliberations began, according to several jurors, she and her peers reported the person to Canone. The juror they reported was dismissed. For George, the fulcrum trial moment was when Massachusetts State Police Trooper Michael Proctor, the lead investigator on Reed's case, read aloud the text messages he had sent friends and supervisors only 16 hours into the investigation. Quote, "There will be serious charges brought on the girl. She's a whack job cunt. Zero chance she
God.
skates.
Wow.
She's fucked."
Whoa.
When someone on the text chain surmised that the homeowner on whose property O'Keefe...
You guys, did you guys hear that? Look at this. The robot is cursing left and right. Oh my God.
and her peers reported the person to Canone. The juror they reported was dismissed. For George, the fulcrum trial moment was when Massachusetts State Police Trooper Michael Proctor, the lead investigator on Reed's case, read aloud the text messages he had sent friends and supervisors only 16 hours into the investigation. Quote, "There will be serious charges brought on the girl. She's a whack job cunt. Zero chance she skates. She's fucked." When someone on the text chain surmised that the homeowner, on whose property O'Keefe was found, would surely receive some shit as well, Proctor responded, "Nope, homeowner's a Boston cop too." Proctor later called the texts unprofessional and regrettable. Earlier this month, the Massachusetts State Police fired Proctor for unprofessional conduct during the investigation of Red. Quote, knowing he was the lead investigator, says George, and based on his own words, he had a pretty strong personal bias against the person in the defendant's chair. How do you ever trust the evidence coming from his investigation? On the day of closing arguments, a juror who appeared sympathetic to the defense was dismissed. As revealed in court earlier this month, the dismissal was prompted by Massachusetts State Police Officer John Fanning, one of Proctor's supervisors who Reed's lawyer Alan Jackson says had been on the whack job text chain. While huddled at sidebar to discuss the reason for the juror's dismissal, Reed's lawyers, Jackson, David Yannetti, and Elizabeth Little, learned that Fanning, an investigator on the case working out of Morrissey's office, had that morning reported an alleged incident he had not personally witnessed that supposedly took place several weeks prior. Quote, there was no evidence presented at the time, as the court knows, Jackson told Canone during a fiery exchange in his motion to dismiss argument on March 5th. There was no declaration. There was no report. There was no supporting documentation whatsoever. Over the defense's objection, this very potentially defense-friendly juror was then excused. I asked the court to take evidence from Lieutenant Fanning. The court declined that invitation. Canone did not dispute Jackson's recollection of those events, but asserted that Fanning did not have direct or indirect access to the jury. In the state of Massachusetts, alternate jurors are selected at the end of trial. Several hours after the aforementioned juror's dismissal, the clerk magistrate rotated a box on a spindle and pulled out 2 tiles.
This is interesting.
He did not show the numbers to the court, but said that they belonged to George and the other juror who had reported the critical juror to the judge. George requested a sidebar with Canone, and she recalls saying that their dismissal from the voting pool did not seem like a coincidence. Canone declined to comment for this story. George had hoped her legal skills could be helpful in the deliberation room, as they had during a previous trial during which she served as a foreperson.
Now, here's the thing. I find this especially... Oh, is Twiz here? Twiz! You got to go back and hear... Dude, I think Franks is doing it. Go back. Some of you guys are just not getting here. Y'all missed some of the best and most amazing in the gutter, dirty, that's what she said. And just, you guys got to go back for like, I don't know how far back, but I think it's worth it. It started with me talking about the thumbnail for this video or this live stream, which says hard as a rock is coming in. And I was like, did anybody get that? And then, yeah, it's y'all. Yeah. And I literally was like, where are the people who would be like dying? I mean, now some of you guys were already dying laughing, but I was like, oh my God, this is just too good. This is too good. So we're listening to the robot read this story. And also, while that's happening, I'm pulling up the latest filings as well. About 10 minutes, Ms. Q says, thank you, thank you, thank you. So yeah, I'm getting the some of the most recent filings. I'm not seeing an order yet that Annie referenced, an order that was in the defense's favor. I'm not seeing that yet, but maybe if you're still listening, can you let me know specifically what that was? But I am seeing some new filings, so I'm just grabbing these while we're listening to the robot read the story here.
In the state of Massachusetts, the judge chooses the foreperson based on a number of factors, such as attentiveness through trial and demeanor. Other times, the decision can be made arbitrarily based on seat number. To preside over the fate of Reed, a woman being charged with fatally hitting her police officer boyfriend, Canone selected a retired Boston police officer to act as foreperson. During the trial, according to 2 jurors, the cop told his peers that he had been hit by a car. According to multiple jurors who have come forward since a mistrial was declared, there was confusion in the deliberation room about whether or not jurors could declare a part.
Sorry, and the other thing I was going to say is this. The part where this juror, who's now an attorney for Karen Reed, said that she thought she could be helpful in the deliberation room. What's so interesting is we heard, and of course that makes sense, right? But we heard literally that exact same thing from Ronnie, the juror, who spoke out and was like, yeah, we could have definitely have used some guidance. Like he even said, like, it would have been nice to have an attorney with us. He said that in all of his interviews. And you know, it's so interesting because he was so respectful and so careful, but you know what he was saying, right? Because now it's, I mean, he knew, he would have known, right? Because they were allowed to talk. He would have known that she was an attorney. So it's just sort of like, I wonder if he said that, like, I don't know. I think he had the foresight by saying that, not to mention anything about this juror specifically, but like, yeah, like that would have been nice. And it's like, oh, and that juror was removed. Yeah.
Partial verdict. Even though the jurors were unanimous in deciding Reed was not guilty of second-degree murder and leaving the scene, they were split on the manslaughter charge. Yet the letter from the foreman that Canone read aloud in the courtroom indicated they were deadlocked on the charges, plural, and a mistrial was declared. Reed has appealed the verdict, claiming that her
That was funny. That
constitutional
was funny.
rights are being violated by being tried for murder a second time. George has 4 children under 5, including infant twin sons, and had no desire to come forward. Quote, I waited for nearly a year after the mistrial, hoping the court system would work as intended to remedy some of the wrongs in this case, she says. During the March 5th pretrial hearing, Jackson argued that Reed's case should be dismissed for reasons of extraordinary government misconduct, including Proctor's bias, investigative failings, the suspicion of jury impropriety, and the fact that some video evidence was withheld from Reed until January 2025. On Tuesday, Canone rejected Reed's request for an evidentiary hearing about the recently surfaced video, which the Commonwealth has called an oversight, and denied Reed's motion to dismiss, quote, because the claimed violations here do not rise to a level that would justify the most draconian sanction of dismission, and because the defendant's constitutional rights can be fully protected in the coming trial. But it was how Hank Breenan, the special prosecutor Morrissey appointed to try Reed this time around, responded to Jackson's allegation of jury tampering that compelled George to speak up. Brennan, who previously defended Whitey Bulger in federal court,
She's not saying it right. It's Breenan.
suggested Reed's claims of extraordinary governmental misconduct were dangerous and reckless, with the potential to cause the public to question the fabric of our entire judicial system. George tells VF, quote, Attorney Brennan implied that the defense was responsible for causing sentiments of distrust in the justice system simply by questioning inconsistencies, inconvenient facts, and missing evidence. At that point, she decided, if as a lawyer I was too afraid to stand up for what I believed in, who would? Even after the circumstances of her dismissal from the deliberating jury pool and the contested mistrial verdict, George had been hopeful when Brennan was assigned to the case. The respected Boston lawyer released a statement last fall saying that one of his core obligations was to make certain that Karen Reed receives a fair trial and the dignity and fairness that every defendant deserves in our criminal justice system. Says George, quote, I was impressed by his background and naively thought that he would see the overwhelming evidentiary issues with the case against Karen Reed. At minimum, I thought he would encourage the Norfolk County District Attorney's Office to dismiss 2 of the charges, given constitutional double jeopardy concerns. George was bothered by another seeming constitutional right at risk in Reed's case, her entitlement to the defense of her choosing. Earlier this month, Canone denied Reed's request to add Mark Betterow, a former Manhattan assistant district attorney, to her.
So I'm just pausing real quick to say, so I've successfully got a bunch of new filings, but I don't have yet what Annie was referencing about a decision in favor of the defense, but I will keep looking. But dude, yeah, this is amazing. The robot cursing was also really funny.
To her team, because Betterow represents Aidan Kearney, the blogger known as Turtle Boy. Canone determined that Reed retaining him would constitute a conflict of interest that is not waivable. George called Jackson shortly after seeing the ruling to express her mounting frustration as Reed's second murder trial approached. George joked that she is still licensed to practice law in Massachusetts should Reed need an extra hand. Over the course of the conversation, the suggestion became less of a joke and more of a potential reality. On March 26th, Reed filed a motion to add George to the team.
I found it.
The case has garnered so much media attention and so many polarized reactions that George hopes the public and future jurors can remember that 2 things can be true at once. Quote, what happened to John O'Keefe was a tragedy, says George, but just because something is sad doesn't mean that the person in the defendant's seat is responsible. I can feel bad for his family and believe she's not guilty at the same time.
Yep. Facts. That's facts. That is facts, guys. I found the one that Happy Annie was talking about. I'm just getting this here so we can look at it, not watch it, look at it. Got it. All right, cool. Found it. So I'm sure that's what she was talking about. She said there was a ruling in favor of the defense. Got it. So let me just, magic of technology here, guys. I'm getting it on my phone. I'm going to put it on the computer in just 1 second. So some of you guys were asking to watch, or I think you guys were asking to watch the hearing from this morning, the short one. It's for Turtle Boy, but Breenan's there arguing in court. Let me know, guys, do you guys want to watch that? So let me just get this here and see if this will work. I think it is. Yep. Okay, cool. Cool. Got it. All right. That worked. So let me just unshare, reshare as we do. Got some brand new docs here, guys. Brand new, hot off the press. So do you guys want to watch the hearing first and then let me unshare, reshare. Do you want to watch the hearing first and then the new docs, or new docs and then the hearing? By the way, so let's just, for the sake of posterity here. So this is the one. So the hard as a rock is coming in, guys, right? Hard as a rock is coming in. And Judge Bev is satisfied. This is what I was joking about earlier, right? Judge Bev is satisfied. She's satisfied, right? See there? She's satisfied because with the hard as a rock testimony. Okay, Carl is weighing in. So the new docs. Okay, we'll do new docs, then we'll do the hearing. So let me pull this one up and share it to you guys. And again, tonight we will watch the Shanna Gardner hearing from today, where there's more "that's what she said" opportunities than I've ever heard in a pretrial hearing in my life. It is amazing. And again, Judge Kite even says rock solid. And I was like, I'm losing my mind right now because, and again, there's reference to an tech expert, Mr. Green. We don't know yet if it's the same Mr. Green as in this case, but maybe. Off to work, but listening. Have fun. Have a good day at work. So, all right. So Commonwealth's motion to compel reciprocal discovery of ARCCA witnesses or to exclude their testimonies. How many times did Breenan say, I'm not trying to keep ARCCA from coming in. I'm not trying to keep ARCCA from coming in. Commonwealth is seeking a viable remedy for the defendant's repeated Rule 14 violations and varying representations about the relationship between the defense and ARCCA witnesses. The Commonwealth does not believe that the defense has complied with Rule 14, nor with the court-ordered discovery. The Commonwealth cannot wait until the middle of trial to properly prepare for cross-examination of the defense experts. In addition, the defense's suggestion that it may request ARCCA to further review and or testing would be in violation of the reciprocal discovery deadline, Rule 14, and the court-ordered directives. Therefore, the Commonwealth requests that this court order the defense to comply and certify its discovery obligations or exclude ARCCA witnesses. If the court is going to allow the ARCCA witnesses to testify, the Commonwealth requests a hearing within 1 week to inquire of the witnesses about their past relationship and their interaction with the defense. So remember what had happened before, right? Was she said that they could do this right before their testimony, but now they're wanting it 1 week before. And why does this make a difference? Because this costs the defense more money. Like Judge Cannoni, like it's silly that they have to do this at all, but her saying that they can do this right before they testify is actually in a way more fair to the defense than what the Commonwealth is asking for, because it means that they don't have to fly them out separately or put them up for an extended period of time, right? They're still going to have to be there earlier. But what Commonwealth is asking for here, right, is they want it a week ahead, which is fucked up, right? Because that's just going to cost more money unnecessarily. To identify any materials the ARCCA witnesses have received that are not listed in their report, and when they received the materials, and the basis for any opinions outside the four listed in their February 2024 report. I know, right? In support of this motion, the Commonwealth states the following. In advance of the trial, the Commonwealth began requesting discovery related to the ARCCA witnesses. The court allowed the Commonwealth's motion. Based on their repeated failures to produce discovery, the Commonwealth moved to exclude the ARCCA witnesses on February 11th. The court recently denied the Commonwealth's request to exclude the ARCCA witnesses. At the present time, 5 days prior to start trial, literally 5 days, says it in the description of this live stream, actually, Commonwealth has yet to receive the required and appropriate discovery and rather received notice on March 25 that the defense is contemplating the possibility of engaging the ARCCA witnesses to provide additional opinions and conduct further testing and analysis. Well, if that's true, that could be a problem, right? The defense's position that material ordered in Exhibit A are not within their custody and control, and therefore they cannot provide, is inadequate. Oh, it's inadequate. It's inadequate, guys. Is it not hard enough for you, Breenan? The defense must comply with the court's order for the defense to call the ARCCA experts as witnesses. Additionally, on March 20th, it was disclosed to the Commonwealth for the first time in an open court that Attorney Yannetti had received a federal subpoena from the USAO to produce his entire, look at the entire in scare quotes, case file. Breenan. On March 25th, the defense further disclosed for the first time that the subpoena Attorney Yannetti was referring to was an ongoing federal subpoena. I have had questions. Hold on. Look. On March 25th, 2025, the defense further disclosed for the first time that the subpoena was an ongoing federal subpoena. I've had questions about this because as far as the federal investigation being over, guys, the only person who has said this is Breenan. Let me liken this to Alex Murdaugh, okay? To Alec, let me say it correctly, Alec Murdaugh and the drug addiction. Let me liken it to that, right? That the only person who has said that is Alex. It came out of his mouth, right? The only person who has said that the federal investigation was closed was Breenan. And he did it very similarly to me, guys. Remember when he first brought up Chloe? This is a few months ago, earlier hearing, right? Where it was during Dr. Russell's voir dire. Never had it come out that there was any existence of Chloe, that Chloe had been tested, that there was a mold done and all that, right? When did it come out? It came out halfway through his heated cross-examination of Dr. Russell. And in my opinion, it seemed like less trustworthy because of how it was like only when he was trying to refute something she was saying and he brought that and it was like, what? The same thing happened when he brought up the federal investigation being over. It was during an argument at one of those recent hearings, and it wasn't like there was nothing to support. It was just him saying it. And I have thought to myself, well, you know, okay, that would be a hell of a thing to fucking lie about. But also, how much do I trust what he's saying, especially in that context, right? Especially in that context. When it's like an emergency situation for him, right? Where he's using it because he's losing an argument, you know, or like with Dr. Russell, he was like trying to, you know, he was trying to give himself an advantage, right? It's like, so anyway, but this is interesting, right? Because what does this say? An ongoing federal subpoena. Look, so are we learning here that it's not case closed? Maybe? DSN, dude, look, I gave you so much love earlier, and I'm going to give you more now. I'm going to give you all of my love, a whole lot of love. Sorry. Our minds have been in the gutter today, my mind, especially because of all these jokes. And it started out with the Shanna Gardner hearing, and like literally it's just continuing on. So here's the thing. We're going to take a look one more time because this is warranted. We're going to take a break. We're going to do this one more time. That's what she said. The witness list. Hang on. Not the witness list. Sorry. The jury questionnaire. Hang on. This is worth doing again. It was so good one time. It was worth doing twice. I'm so glad you're here, DSN. All right. Wait, wrong thing. I clicked on the wrong thing. All right. I wanted to say that I said this earlier, I'm going to say it again because DSN's here. So that I, as a non-Reddit person or what have you, yes, that's right, Carla. Yes. As a non-Reddit person, right? I figured out how to post on Reddit so I could post this. Okay. And if you guys go to the Reddit for the Justice for Karen Read, you will probably see this and people are loving it. And I don't know how to use it enough to where I could have possibly given, like, I literally just posted it and that's it. Like, that's all it is. But you guys can probably find it on there and people are loving it and giving it all the votes and commenting. And so anyway, huge shout out to DSN for starting this, but we're going to read it one more time because it's amazing. So question number 1, and again, look at this, the 623 at the top, right? I made it look just like the real thing. Number 1, are you a McAlbert? Number 2, have you ever answered a butt dial? Number 3, do you generally drive through a military base to destroy your old phone when you are upgrade eligible? Number 4, have you ever eaten a PB&J in the backseat while being brought home by a drunk driver? Number 5, are a piece missing and smashed to bits logically equivalent to you? Number 6, when gathering evidence, should party favors and lawn equipment ever be used? Number 7, would you like to sit at the bar or at a high top? Number 8, do you have a problem with people wearing shoes in the house? Number 9, when publishing a lollipop video, is it always correct to flip it and reverse it or put your thing down? Just had to do that. And I loved this one because of the sad and mad in the original question here. Are you a member of Todd, Troopers Okay with Drunk Driving, or God, Cat and Cops Okay with Drunk Driving? Number 11, can you tell the difference between dog bites and injuries caused by a triple pirouette following an automobile strike? Number 12, are you okay with a little police corruption, assuming they really believe that she did it? Number 13, who, if anyone, was driving the ambulance? Number 14, have you ever spent more than one night at Bev's Cape House? And it's really funny because some people are like responding in the comments on there of like, they're going to have to approach on this. It's really fucking funny. People are loving it. So shout out to that. Anybody can join the Discord. Anybody can join the Discord. Yeah, anyone can join the Discord. So you can invite her. I believe. I mean, yeah. And then again, anyone can also just like search for Law Squirrel and should be able to find it that way too. So, okay, so now we'll go back to what we were reading, but I just wanted to do that in celebration of DSN because that's amazing. Okay. Right. So we were talking about this, right? So the ongoing federal subpoena. So what the fuck's happening? On March 25th, 2025, the Commonwealth was first informed that the discovery produced to the defense was in turn being provided to the United States Attorney's Office in an ongoing manner and included the entirety of the Commonwealth's discovery referenced in notices of discovery 1 through notice 57. Footnote 1. Oh my God. It was provided to the defense. Notice 57 was provided to the defense on January 30th. Okay. When was it that he said the investigation was over? That was recently, right? The Commonwealth still seeks the following discovery. 1, all bills, invoices, contracts, retainers, engagement letters, or payments that have been created for the defense of Karen Read or provided to or from the Read defense team from March 1st, 2024 through present. All emails, letters, or written correspondence, including text messages at any time between any employee of ARCCA and any member of the Read defense team, including Karen Read. Number 3, all phone ledgers evidencing phone calls or text messages between any employee of ARCCA and any member of the Read defense team, including Karen Read at any time. All written communications or a summary of oral communications between any employee of ARCCA and any member of the Read defense team, including Karen Read, relative to any facts, claims, or documents produced or any other information about this incident that is not listed in the February 2024 report. So this is really Breenan trying to still keep them out, right? By saying there's, outstanding discovery. Now, again, there's only so much that can be done because the feds are the feds, right? But a written summary of all testing and findings that were conducted by ARCCA employee Scott Klein. Look, he wants the other ones, dude. Okay. And Jeremy Robbins, the source of all information on DNA and forensic evidence that was provided to Dr. Wolf and Dr. Rentschler prior to their trial testimonies. Super Planner Girl, welcome. I'm glad to see that you are feeling some improvement. That is awesome. That's awesome. I'm very happy to hear that. That's good. Twiz coming in clutch with the Super Planner Girl command. Thank you, Twiz. Number 7, all data, photographs, videos of any testing, regardless of whether testing is the basis for any opinions. This request includes all data and memorialization of any failed tests. A copy of the federal subpoena received by the defense team referred to by Attorney Inetti. Number 9, an exact copy of all materials that the defendant provided to the USAO, including a list of all content or of the content of all materials provided to the USAO. Data of each submission was provided to the USAO. An exact copy of all the materials provided directly to ARCCA. The defense's TUI request to the United States Attorney Office following the March 4th, 2025 letter and any subsequent responses. If all the requested discovery is not provided to the Commonwealth or a defense certification that each request has already been provided, the Commonwealth requests the court exclude the ARCCA witnesses. Now, here's why this is dumb, or not dumb. This is cruel, really. Cruel and unusual punishment. Because they don't have the ability, right? Like he's saying they should be excluded. But this is not in their control because it's the feds. And he knows this. So basically, this is like saying, and this is filed by DA Morrissey. Fucking hell. Well, I guess by Hank Breenan before Morris. Anyway, You see what I mean? It's like saying if they can't do this thing that they can't do, then they should be excluded. Are you talking about for Discord there, Twiz? Jury selection starts in 5 days on April 1st. And then the trial, they don't know. Judge Bev said she thinks maybe 3 weeks for jury selection. What's this about being subscribed here? Oh, you're talking about being a member. Gotcha. Oh, yeah. I have heard from other people that is, you can't do it on a cell phone. You can't do it on a cell phone. That's what I've heard. I don't know why that's the case, but that's what I've heard, and that you have to do it from a computer. If you do it from a computer, you should see the join button. Yeah, we would definitely want to have you as a member for sure. We've already had a lot of members only stuff, and we've had so much fun on Never Have I Ever. We're going to do Never Have I Ever again. And Amanda will love to be part. I know she will want to be, and then again, on the next one, we're going to do trivia again, get y'all's categories in if you haven't already. I'm going to say probably by tonight or tomorrow, so I can start compiling the questions, because we will do our members only special trivia night next week. And you can still participate if you don't get a category in. It's just if you want to give yourself a handicap, again, in a good way, right? Where you're like, this is my category, right? Anyone can still do it. But if you want to have that advantage, strategic advantage, for those of you guys that are competitive, you're going to want to get your category in. Oh, okay. Gotcha. Yeah, no rush. And the other thing I'll say is this. So Twiz, Frank's was the best. Everybody was like, we all want to hang out with Frank's and Too Fast. Y'all, they tied for most lived life experiences, and we all want to hang out with them. Dude, Frank's that was so much fucking fun. That was so much fun. We love it. One of the best ones, right, was like when I said never have I ever had a threesome, and the number of people that were like, and it's like, oh yeah, we know that. So good. So good. It was so good. So I was gonna say also, let me go to the next one here. I want to say also that Twiz has a link to jump on. I'm going to give Twiz links for all these. I'm going to see if I can figure out how to give him a permanent one. But I was going to say is this. If Twiz wants to, and it's okay if he doesn't, if Twiz wants to jump on and read any of these documents, because A, you know, for anyone who hasn't like heard Twiz, like Twiz is got that Pullman accent, I guess, Washington accent, but also he's hilarious. And if he feels so inclined and wants to jump on, I mean, he doesn't have to read them, or he could just basically, I want everyone to know that Twiz has the ability to click on a link and jump on at any time and, you know, chime in or do whatever he wants, but he doesn't have to. Just saying. Twiz reads. That's exactly it. We want Twiz. Thank you. I knew you guys would back me up. I knew it. Yes, we want Twiz. The people will revolt otherwise. Twiz reads. Yes. Twiz reads. This can be a new segment. Twiz reads. Yes. And you know what? Did you intend the pun because of Karen Reed? Because either way, that's hilarious. Twiz reads, Karen Reed. What do you guys think? And I can continue to, you know, scroll and everything as you read along, because I don't know how that will work. If you can do it or not, I guess you can't. It's on my computer. But don't worry. We'll figure it out. Yeah. So let's see what happens. Let's see if he magically appears. You should have the link. Oh, I got a notification. It looks like Official Sister successfully joined the Squirrel Crew. So that's awesome if that's the case. Woo! Twiz. Actually, we should have him do this one first. Hold on. We should have him do this one first. Let me share this to you guys. We're going to have him do this one first. You're going to have to come on now, Twiz. We want to hear Twiz read this. I do anyway, about the hard as a rock and Judge Bev being satisfied. And You can't read it because you're on your phone. Fuck. No. God, that sucks. That sucks. What if I make it really big? What if I make it really big? Or if I send you the doc, if I could, like, what if I send it to you separately? Let me try that. Let me see. Can I do that? I don't have this one on my phone though. Damn it. I can make it really big. Oh. When can you get to your computer? Turn your phone sideways. That's a good idea. I wonder if it would look different for you though if you jump in versus watching. Would it be bigger? Let me know what's happening if you can get to your computer, or you can still jump on anyway, right? It's smaller if you turn it sideways. What if I let me see what happens if I take, let me try this. Let me try something real quick. The magic of technology. Thank you guys for being patient. Let me see. What if well, the other thing is if Twiz needs time to get to his computer, what we can do is we could watch the hearing, the Turtle Boy hearing, and then come back to the documents. So that's a possibility. But let me see what happens if I'm going to take a picture and send it and see if that makes any type of difference. That's how badly we want Twiz reads. Twiz reads Karen Reed, you know? Let's see. Okay, I'm going to send this to you. That might not help. I tried to take a picture of it on my computer. Let's see if that is helpful at all for you though, Twiz. I'm going to text this to you. I don't know if that will make a difference. Okay. When can you get to your computer? Right. She turns her phone. Right. That's what she's. Thanks, DSN. Thanks. You guys are the best. You guys are the best. And thanks for being patient as we try to figure out how we can. Right. So if you open up StreamYard, okay. It might be so it's different because he has to join through StreamYard. So if he opens that link, I think that's where he can't do anything with it. It might be that okay, like if we watch the hearing, he could still chime in for the hearing, right? Like, but as far as reading documents, that might be something he has to do on his computer. So let me know what you want to do, Twiz. Should we start with the hearing until we figure out how to get Twiz for Twiz reads? If you think you might be able to get to your computer. Because we want to hear Twiz read this one. But this is the one that was new that I was going to be reading here. Right. So you could still jump in as we listen to the hearing if you want to, but it seems like if you're going to be reading, you might need to. That's good to know. Good to know for future reference that you would need to be at the computer more than likely. Or definitely, probably. Breenan. Okay, while we're waiting to figure it out, I'll read this next one because there's more. There's more documents. There's more where this came from. All right. Affidavit of counsel in support of Commonwealth's motion to compel reciprocal discovery of ARCCA witnesses. So from the document we just read about the discovery for ARCCA, right, here's Hank Breenan's affidavit. Again, he wasn't including affidavits, but I think he knew that people were making fun of him maybe. Because now we're seeing affidavits, right? My name is Hank Breenan. I've been appointed. Okay, fine. The Commonwealth sought and obtained a court order for discovery pertaining to ARCCA witnesses on December 5th, 2024, Exhibit A. The Commonwealth has repeatedly informed the defense and the court that it believes that Rule 14 and court order discovery has not been satisfied. It's not been satisfied, guys. Twiz, this is why we need you. It's not been, Breenan's not satisfied. On March 20th, 2025, Attorney Yannetti disclosed to the court for that typo. He had received a subpoena. Look at the subpoena in scare quotes. What is going on? What? From the United States Attorney's Office to produce his entire... I'm losing it. Subpoenas in scare quotes, entire is in scare quotes, case file. The Commonwealth was unaware of this information. Additionally, the Commonwealth has no idea what Attorney Yannetti provided to the United States Attorney's Office, nor does the Commonwealth know what was provided to the ARCCA experts other than what is listed in the group ARCCA report. After court on March 25th, the defense disclosed the subpoena Attorney Yannetti was referring to was an ongoing federal subpoena. I have questions about that. Commonwealth now understands that the defense had or has been providing all discovery to the United States Attorney's Office in an ongoing manner, all material outlined in the Commonwealth's notices of discovery 1 through Notice 57. On March 25th, 2025, the Commonwealth learned that the defense may ask ARCCA to engage in further review, analysis, and testing, which could result in further discovery. Discovery deadlines have passed. The Commonwealth will not be able to fairly prepare its expert witnesses for new materials, testing, or opinions. The Commonwealth will not be able to prepare for new opinions beyond the previously provided report. The Commonwealth cannot adequately prepare for trial without all court-ordered and Rule 14 discovery. Okay. We've got more docs. What we're going to do is we're going to switch over to the hearing while we figure out what Twiz is going to be able to, if Twiz can get to a computer and for Twiz reads. So we're going to jump on over to that. And again, he could still join to you, Twiz. I guess I could say it to you in first person. You could still join to comment on the hearing if you feel so inclined. But yeah, so that way you don't have to have any issues with the reading. But there we go. Let me just, they changed where they put that logo, which is funny. Okay. We have the fan, the only fan.
Followed by pound.
Okay, so yeah, so some people already said that they have some Karen's attorneys are there remotely or whatever, so that's them getting that shit figured out. All right. No, too much pressure. No. We love you. We want Twiz.
I did.
Enter your participant ID followed by pound. Otherwise, just press pound to continue. You are in the meeting now. There are 13 participants in the meeting. You have been added to the waiting room. You cannot talk or listen until the host admits you to the meeting. You are unmuted.
Oh, attorneys and technology. This hearing happened at the same time as the Shanna Gardner hearing. And they're like, I have to be unmuted for it to work. Like they're trying to figure this out. And this is like so fucking basic. I love it. I love it. Oh my God. Wow. They don't know how to do it, guys. Oh my God.
You are unmuted.
Hello? Oh my God. Wow.
You are muted.
Wow.
You are unmuted.
Oh my God. Get it together, people.
I muted everyone. Okay. We're going to go back to the other way.
Oh my God. What a disaster. I love it.
Okay. Chairman after this. With, Judge Gilman.
You know, and that, so yeah, the Twiz. So Twiz, if you don't read it, you can just jump on for the commentary, right? Whether it's documents or the hearing, anytime you want to jump on, literally you can jump on, and we will be happy. I know, I agree. I know she meant to say cracks up, right? It always cracks her up that the script boyfriend cop murder trial. I know it is. I just, it's dumb. Yeah. I'm like, y'all, it's gone way past that now. For real. Facts, Amanda. Oh, God. I know. I have an idea.
Hard as a rock, freeze thaw effects on penetrometer resistance. You know, his head's as hard as a rock.
Your Honor, I can't do this in 2 minutes.
I'm thinking of ways to lure Twiz on taking us up on coming on. It's okay. It's all good. We know. It's all good. The craps was funny. By the way, for anyone who missed it, right, you can actually buy penetrometers, and Amazon actually sells a pocket penetrometer, and it includes a scale for max hardness. So in case you need your penetrometer on the go, pocket size, because you got your one at home. And also, how many penetrometers does Judge Bev have, right? Okay.
What? Thank you.
Until the host admits you to the
What a mess. Oh my God. Oh my God. This is my favorite thing of all time. Okay. You guys know how it all says music or applause, and it never is. It's actual music. I can't. So this is the hearing. Yeah. So this is Breenan. Breenan's going to be there with the other judge. This happened at the same time as the Shanna Gardner hearing, which I plan to cover probably later today or later tonight. But yeah, they're trying to get, it involves Karen Reed because they're trying to get all these communications.
cannot talk or listen until the host admits you to the meeting.
Oh my God, this is amazing. This is my best. They're actually playing music. Oh my God. What even is this? This is the best thing ever. Literally, it makes me realize that this might be the first time I've ever heard music played in a courtroom. Like it's now, I hadn't realized that. It's just now dawning on me that music is never played in a courtroom. Maybe it was at some point during the YSL trial or something. Maybe. I think the state wanted to bring it in and it wasn't allowed, but I don't even remember. I don't remember hearing any of it. Anyway, but that would have been rap lyrics. Anyway, but this is like, I'm like, wow, this is blowing my mind right now. Oh, they did? Okay. I just can't remember. That was so long ago.
You are muted. You can mute or unmute yourself by pressing *6.
Did they play it in Zachary? I don't know that they played it in the trial, though. They talked about it. They didn't play it in the trial. I'm sure they didn't. We watched the videos, but it was not played in the trial.
You are unmuted. You are muted.
Okay, now I'm sorry. I'm not ready. But I'm
You are unmuted.
Can everyone hear me?
Yes. I don't think so. They might have shown like a picture. I don't think they played the video, which they really should have. I don't know why I would have remembered that. Yeah. Because I would have commented on like what the composer was and all that, right? Yeah. No, we watched the videos. They did not play them. They talked about it, but yeah, no, they didn't. That would have been an opportunity though.
Just so you know, we hear a big echo. I think two people might be in the same room, and that might be causing it.
Oh dear. Where is Twiz? Okay, here we go. So the Judge Gilman, I forget.
Judge, this is 22117 and 23313, Commonwealth versus Karen Reed, and separately the Commonwealth versus Aidan Q.
Okay.
Can I have the parties identify themselves?
Mr. Clerk, hold on just a moment, please.
Sure.
I need to plug in because I believe we have parties on Zoom.
Okay, I'm sorry.
It's also my understanding that we're only here on case 0117.
That was also my understanding.
Okay. And do you have the Zoom identification link for me,
I
please?
do. I do. It's right here.
Thank you.
Thunder!
Thank you.
Well, we've been Fender wants to know how long we've been going. We've been going hard. We've been going hard for an hour and 40 minutes. One could say hard as a rock if one felt so inclined. We're also trying to get Twiz to come on. We want Twiz. I think his name is Judge Doolin, if memory serves. I don't remember. There's that same box though. That same cleanup stuff. There's Breenan.
Karen Reed, can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Hank Brennan for the Commonwealth, relative to docket 00117.
Good morning, Attorney Brennan.
Good morning, Your Honor. I'm Robert Cosgrove. I'm the special prosecutor on the Aidan Kearney cases, and I suppose for purposes of this motion, I'm the respondent to the Rule 17 motion.
Good morning, Attorney Cosgrove.
Good morning.
Hello, Your Honor. Timothy Bradel for Aidan Kearney. I see him on Zoom for the record.
Good morning, Attorney Bradel. Good morning, Mr. Kearney.
And Mark Federer for Mr. Carney. Good morning, Your Honor.
Good morning, Attorney Bradel.
And good morning, Judge Attorney David Yannetti for Karen Reed, who is also present on the Zoom.
Good morning, Attorney Yannetti. Good morning, Ms. Reed.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Attorney Little. Anyone else here that we need to recognize before we proceed? Doesn't seem so.
No.
Okay. Folks, we are here on two related matters this morning. As an initial matter, we are here because there seems to be some confusion concerning my order of March 20th on docket 615 on the Commonwealth's Rule 17 motion. Also, we're here because there has been a motion for protective order, docket 636, filed by intervener Kearney, and so we will hear that as well. So with regard to my order, let me start by saying this. Going back to Attorney Brennan's affidavit filed in this case on March 5th, 2025, in support of the Commonwealth's motion for records, Attorney Brennan, you specifically stated that, quote, it's been represented to the court by defense counsel Bradel on behalf of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the three categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged.
Oh boy.
So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Reed during the time frame in question with regard to these three articulated categories be produced.
Okay, I just have to pause real quick. We're going to listen again. It sounds like he's letting Breenan have it, which I love, and it's about time, and this is like making my day. Also, Twiz is also wanting, sorry, oh my God. Kane also wants Twiz to come on.
Of Mr. Kearney that there's an implicit long-term mutual assistance and mutual defense agreement between counsel for Mr. Kearney and counsels for this defendant, Reed. On the basis of that sworn statement, I specifically inquired of you, Mr. Brennan, at the hearing on this matter last week, do any of the three categories of documents and data that the Commonwealth seeks by the Rule 17 motion include communications with Mr. Kearney and counsel for the defendant in this case? You replied, no, these would be privileged.
Fender with a great question. Why is Twiz not twizzing? This is what we're trying. This is for Turtle Boy official. This is Turtle Boy. That's why it's a different judge. Yeah, why is Twiz not twizzing? Great question.
So based on these representations and the court's belief that there were no privileged materials implicated by the Commonwealth's motion, I ordered that all communications between Mr. Kearney and Ms. Reed during the time frame in question with regard to these three articulated categories be produced. However, subsequently, the special prosecutor in Mr. Kearney's case, in possession of the documents in question on March 26, informed the court that, one, there are in fact a substantial number of communications within the documents and data requested that are indeed communications between Mr. Kearney and Ms. Reed's counsel. And moreover, the special assistant district attorney in that case took the position, contrary to the one asserted by Attorney Brennan in this case, claiming that those communications are not, in fact, privileged. So My order did not specifically exclude from production communications between Mr. Kearney and Ms. Reed's counsel because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Breenan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for Special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
This is freaking amazing. I'm living for this. This is the moment we've been waiting for. Wow. I don't know why Kane says the Twisvite is sealed because, yeah, so he has an open Twisvite. Oh my gosh. Oh my gosh. Like, this is just so worth listening to again. Like, he's letting him have it. I love it.
Counsel, because the court was told there were no such communications, and in any event, the Commonwealth acknowledged that they were privileged. So my first question is to you, Attorney Breenan. Respectfully, did I misunderstand you, or perhaps vice versa? In other words, I understood that you weren't requesting the production of any privileged communications, to wit, communications between Mr. Kearney and Ms. Reed's counsel. And as such, if that is the case, and we did understand each other, I can simply clarify my order for Special ADA Cosgrove that those claimed to be privileged communications will be excluded from the Rule 17 production, and we can move on. If that's not the case, I'd like to hear why.
Wow.
Yeah.
He
Yes,
is
you may.
pissed. Oh my
I
God.
think there are two separate issues regarding privilege. One is
Two separate
whether
buckets.
Mr. Kearney's attorneys, Mr. Betterow and Mr. Brado, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney. When Your Honor asked the question, I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other.
Or I misunderstood. I'll take responsibility for it. But I was trying to be protective of the attorney-client.
I'm shocked. I'm going to put this on normal speed. This is crazy. This is blowing my mind. This is him. He's getting called out for his fuckery. I want to make sure I'm understanding what even, because I haven't watched all the stuff with Turtle Boy, but I want to hear what is there.
May I?
Yes, you may.
I think there are two separate issues regarding privilege. One is whether Mr. Kearney's attorneys, Mr. Betterow and Mr. Brado, have privileged communications, and separately, Ms. Reed's attorneys' communications with Mr. Kearney. When Your Honor asked the question, I believe we were referring to Mr. Kearney's attorney. And so what I understood from the motion filings is that there were no privileged communications between Mr. Kearney and his attorney in those phones. And so there would be nothing privileged to protect.
Okay, I specifically asked, does this
information, they need a taint attorney, right, guys? Taint attorney, we all know taint attorneys.
include communications between Mr. Kearney and counsel for the defendant, Reed?
I don't doubt that you asked that if that is what happened, but that wasn't my answer to the question because perhaps I was focused more on Mr. Kearney.
So you confirmed today that we misunderstood each other.
Or I misunderstood. I'll take responsibility for it.
my
But I was trying to be protective of the attorney-client privilege between Mr. Kearney and his attorney, Mr. Brado, Mr. Betterow.
Okay,
I did
well, we
not-
all agreed, counsel, that those in fact would be privileged communications
Of course.
without question.
Of course.
So let's turn to, if you would, the second issue, which is one that you raised in your affidavit. You specifically raised that question in your affidavit, docket 547.
Undoubtedly. I do not believe there is any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Reed's lawyers are attorneys for Mr. Kearney.
Hang on.
Your affidavit, docket 547.
Undoubtedly. I do not believe there is any attorney-client privilege between Ms. Reed's lawyers and Mr. Kearney, because those communications are not covered by attorney-client privilege because none of Ms. Reed's lawyers are attorneys for Mr. Kearney. I pointed out that in an earlier hearing, and I have the transcript of it, it was December 17, 2024, when there was litigation in Mr. Kearney's case, docket 0313, that there was a position taken by Attorney Bradel. And he began by telling Judge Krupp, well, there's a joint defense issue, Your Honor. And Judge Krupp asked, so it would predate any jeopardy of Mr. Kearney. And then Mr. Bradel responded, well, it's a little more complicated because we know he was under investigation along with Ms. Reed without any resultant charges. So
Make the coffee. Make
that
the
does not fall
coffee.
under the umbrella. After more questions by the court,
Ella,
Mr. Brandon answered, we don't have an agreement, but there's been an ongoing long-term implicit mutual assistance and mutual defense that I myself have been part of for a long time, and Attorney Bedrow has as well. And Judge Krupp said, I really have no idea what that is. And so inevitably, there was no establishment of an attorney-client relationship between the two. Inevitably, and after that, Attorney Bedrow attempted to file an appearance on behalf of Ms. Reed. And in that, there was a supplemental motion, and it's docket 549 on 0117.
And docket 549 contains Attorney Yannetti's sworn statement that there was no joint defense privilege between Ms. Reed and Mr. Kearney.
Exactly. And so I think I had the assumption there was no attorney-client privilege. If I misspoke, it confused the court. My apologies, but inevitably, there is no attorney-client privilege that I understand exists. And so I do not know what is in these phones. I have not asked. I don't want to know unless it's pursuant to a court order. But based on the affidavit of the search warrant and based on the pleadings in this case, and there's two very important pleadings, I may have mentioned them to the court on the last date. But those pleadings, which were filed publicly by the Commonwealth, and it's docket number 53 relative to Mr. Kearney's case 0043. In that pleading, it is set out by the Commonwealth pleading that there is, in fact, information demonstrating that the Reed team provided Mr. Kearney with information, documents, videos. It suggested that at times they would suggest angles for him to use it or to refrain from using it. And it provides a number of examples, including an example on 8823 when they're asking for information, Mr. Kearney, so one of the attorneys.
Attorney Brennan, I'm going to ask you to pause right there because I think we've reached a point where I have a threshold issue that may require either a Bishop Franklin protocol.
Oh, no, not Bishop Franklin. Uh-oh, Bishop Franklin.
Or some inquiry into the nature of the privilege that may or may not be asserted by Attorney Bradel. And so I think it's appropriate at this time, Attorney Bradel, that I turn to you, not with regard to the protective order, but with regard to the issue of whether your client claims a joint defense agreement and related privilege to communications between himself and attorneys for Ms. Reed, such that I need to limit the scope of my order of March 20th.
Judge, thank you. We do not assert such a privilege. I said in a much different context a long time ago that we had been sharing information and talking to each other and helping each other. And I said that there was an issue. I didn't say there was a privilege.
Okay.
So we are not asserting that. There is no formal agreement. There's no formal privilege. I said it was an issue to be looked at the time. That's all I said, Your Honor. And in terms of this, Your Honor's order, I don't even know why we're talking about this, Your Honor. The ostensible purpose of the Commonwealth's request was to attempt to show consciousness of guilt on the part of Ms. Reed. So why would communications to other parties besides Ms. Reed have any relevance? And in fact, in your order, you just say that the only communications that are on the table here, so to speak, are communications between Mr. Kearney and Ms. Reed.
I'll stop you right there, Attorney Bradel, because you raised an excellent point. And that point being is that point from the court's perspective is in an age of group texts and other means of communications with multiple recipients at the same time, we certainly have the likelihood of communications between your client and Ms. Reed that may also include members of her defense team. So it is my belief that that is what might be at issue, but I will probe further of ADA Cosgrove on that point.
I mean, if you ask me, Your Honor, the pleading, that the impounded pleading filed by Mr. Cosgrove is completely immaterial. The whole reason for this is consciousness of guilt. So there are we're privy to these extractions. There's absolutely nothing in them that is covered by Your Honor's order. There's no communications between Mr. Carney and Ms. Reed regarding witness intimidation. There are none. So there should be exactly zero documents or texts or emails that should be responsive here. Absolutely zero. And I don't have the thumb drive that Mr. Cosgrove gave to the court ex parte. So I can only imagine what's in that. And we are anticipating a request that you will look at that, to ask you to look at that in camera and see if that complies with your order. It doesn't. It cannot comply with the order. Your order said Carney and Reed, not third parties that may or may not have spoken to Reed. And these are things that are privileged among that team. So this is a can of worms that the court did not open by any stretch. And I think that, Mr. Cosgrove's role here is completely ministerial, Your Honor. And the fact that he's trying to jump outside of your order is incredibly inappropriate, in particular because these two prosecutors are in different positions due to a conflict of interest, an express conflict of interest that has been identified.
I agree. He is
supposedly
handsome.
acted on by District Attorney Michael Morrissey. So their communications need to be limited because there is a conflict. Your Honor limited those communications very appropriately to potential evidence that those two defendants could have communicated and in terms of some criminal acts. And we're telling you there's nothing there. We don't expect you to rely on our interpretation, but there is nothing there relative to your order.
Thank
So
you.
the fact that this
Attorney Breda, I'm gonna ask you to pause for a moment, and I'm gonna hear from Special Assistant District Attorney Cosgrove, specifically with regard to this issue. In your communication to the court, you suggested that in your judgment, the production would sweep in a substantial number of communications between Mr. Kearney and Ms. Reed's attorneys. How would those be swept in when the order specifically calls for communications between Mr. Kearney and Ms. Reed?
I think the actions of Ms. Reed's attorneys on her behalf are the actions of Ms. Reed. And if one reads the sweep of the communications between Mr. Yannetti and Mr. Kearney, and between Mr. Jackson and Mr. Kearney, and Ms. Reed and Mr. Kearney, one sees a pattern of feeding information to Mr. Kearney. I think that they act together in that respect, Your Honor.
Thank you, Attorney Cosgrove. Notwithstanding that position, the court's position is that the order spoke very specifically and very clearly to limit the Rule 17 motion to the production of only communications between Defendant Reed and Kearney and Defendant Kearney.
Hello.
Concerning those three
Shout out
areas.
to official sister. Excellent. Esmeralda, welcome. We're happy to have you. So happy to have you. Love it.
Of inquiry. So I am specifically requesting and ordering the Commonwealth in that case to review the documents called as a result of the Rule 17 motion in my subsequent order, such that the production will only include communications between Kearney and Reed.
Well, I will, of course, comply with Your Honor's order.
Thank you. Folks, I think we've covered that point, and I don't think I need to hear any further on this. The order is clear on its face, and I expect the parties to comply with it. I'd like to turn now to the issue of the motion for protective order from Mr. Grado.
I'm still trying to get Twiz to come on.
So I'll hear you on this, appreciating that I have had the opportunity to review the attachments and certainly the basis for this, but I'm not, I'll preview where I end up, Attorney Brado. I'm not quite clear on the scope of your request as contained in your draft order. As an initial matter, I'm only issuing an order in the Reed case. I am not, this is not a hearing on the Kearney case. I appreciate that you have a congruent request to the court in the Kearney case, and that it may make sense that whatever the court does in that case should follow what the court does in this case. That would seem to make sense. But I'm only hearing the motion as it regards to this case. Your request, I'll note, asks that the court order all prosecutors and police in the above captioned case to maintain the confidentiality of the cell phone data and any other investigative information and or discovery in each case. So I'm not prepared to discuss the entirety of investigative information and all discovery in this case. I'm tasked with only addressing Mr. Kearney's specific cell phone data that is the subject of my order of March 20th. But you've specifically requested that the court order that police and prosecutors are ordered to refrain from sharing such information with particular parties identified in Mr. Kearney's affidavit and any other parties not part of the retained prosecution teams of Ms. Reed or Mr. Kearney. Aren't they already under a duty not to share such information with anyone outside the bounds of what you request?
They are, Your Honor. Judge Cannoni specifically found a substantial risk existed that any further communications about the evidence or the witnesses would jeopardize a fair trial. And she made that specific finding, and she imposed, I believe it's a 4-part gag order on the Reed attorneys. Nonetheless, as shown in my exhibit, Judge, these outside people are receiving information that in no way
that's funny. Yeah, no, I like this judge. I like this judge.
Outside of
Twiz.
anything ethically share anyway, any such information.
Twiz is lame. Twiz says he's going to fall asleep again. That is lame. Sleep is for losers. You can sleep in your dead, Twiz.
And there's 3 examples of people who are, out there saying we've gotten this, we've gotten that, and we strongly believe that they are doing so. Just to avoid the slight awkwardness, Judge, of me arguing something that benefits Ms. Reed, I would invite, just for the record, the Reed counsel to join me in this motion, Judge, because of the leaks that are going on, just as a threshold matter, if I may do so, Your Honor.
Are you merely asking me to add a belt to Judge Cannoni's suspenders?
I think so, Judge, because we need one, and we need one as to the specific information. These 3 people have repeatedly stated that they're privy to inside information, and with respect to Mr. Kearney's information, but although we strongly contend there's nothing in there that is responsive to Your Honor's order, nothing. To the extent that there's anything that's shared between these 2 different prosecutors that are on separate islands due to a stated conflict of interest, we want to specifically ensure that as to the discovery that Your Honor's focused on here, that these orders are in place, that there's a specific order. It's sort of another step from Judge Cannoni. She said that, well, the general rules of ethics aren't working here, so I'm making a specific finding. I'm giving you a gag order. Well, guess what? Judge Cannoni's order didn't work either, based on my exhibits A, B, C.
I mean, one could take it and run here with the gag order after all the other things, right? You guys know what I'm saying?
Another step to just really put a fine point on it, that these 3 people must stay away, and a general order as well as part 2 is my part 2. And to the extent that those people have any sort of further expressions of leaks in the media or on the internet, I think that ought to be grounds for a live hearing with sworn testimony about these leaks.
Understood. Okay.
So that's why I'm asking, Judge. Thank you.
Thank you, Attorney Brado. Attorney Yannetti, do you have anything to add on this point?
We don't. I mean, I think that.
Well, let me know. You guys, let me know in the chat, guys. You know how when we were playing Never Have I Ever last night and one of the ones was handcuffed? Does anybody, let's Judge Bev. Who, if anyone, thinks Judge Bev has ever been handcuffed? And if so, for how long has she been handcuffed? If she has.
generally take no position here. It is concerning to me that Special Assistant District Attorney Cosgrove revealed in a publicly filed motion communications with, or I should say between Mr. Kearney and counsel for the Reed team when the court's order was specific. My understanding is that he omitted some statements of caution and admonitions that we may have given to Mr. Kearney about the nature of demonstrations, etc. So it seems as though he cherry-picked statements in an effort to make us look bad when it was outside the court's order. It was unnecessary.
Attorney Yannetti, are you speaking to something that Attorney Cosgrove has purportedly done in this proceeding in the 117 matter?
No, I believe it's a motion that he filed in his prosecution. Again, detailed, that material.
Thank you. Okay, folks, I will take that matter, the motion for protective order, under advisement, and will endeavor to respond to you as soon as practicable on my decision on that. In the interim, ADA Cosgrove, Special ADA Cosgrove, I ask you how soon do you believe the Commonwealth can reproduce the records in question?
She did say she was satisfied when it came to Mr. Hard as a Rock.
Motion.
Mr.
Well,
Penetrometer.
I'd say we can probably extract from the thumb drive the conversations with Mr. Yannetti and Mr. Jackson. I may be able to get it done today. I think Monday would probably be a realistic filing date.
Thank you. We'll expect something by close of business Monday. And if you encounter any difficulty or challenges in doing that, just please let the court know and we'll make whatever accommodations we need to make. Okay, folks.
Your Honor, is that thumb drive going to get returned to the Commonwealth?
Yes, it will.
All right, thank you.
And it has not been viewed, it has not been released, and it is being held under seal and impounded at the moment, and it will be returned to the Commonwealth promptly.
Thank you very much, Your Honor.
Attorney Brennan.
Your Honor, just for clarity of the record, I'll be brief. There's been no conversations between Special Prosecutor Cosgrove and I about contents of any of these items. In fact,
why do I not believe that?
I had to. That's why I filed the Rule 17, so there is a clear public
record
that we're beyond reproach. Secondly, the pleadings I referred to were pleadings that were filed in Mr. Kearney's case publicly before this issue even came up. So it is not divulging information to disseminate to the public. And finally, just so it's crystal clear, I filed a motion for a gag order in Ms. Reed's case because there was significant evidence of distributing protected materials, and that order was allowed at my request. There is no witness or person, as far as I know, in the Reed case that has disseminated any information improperly. I would not allow it or tolerate it if it happened. So I want that to be crystal clear based on the representations we just heard.
Understood. Thank you, Attorney Brennan. Thank you, Attorney Cosgrove. Thank you, counsel. No, we are adjourning the hearing now.
Oh,
Thank
wow.
you, counsel.
Wow. All right.
Thank you.
Thank you, Your Honor.
That's not fair, though. You let Breenan speak again.
Goodbye.
Wait. That's the best ending.
Thank you.
Thank you.
Thank you, Your Honor.
Goodbye.
Oh my God. That is so funny. Is Mastermind a show, a movie? I haven't seen it, whatever it is. We're still trying to figure out why Twiz is being so lame. But in the meantime, all right, so we will now go back to finishing up with these latest filings here. Oh, I can make it like this. And it looks like there's still more filings coming out. I mean, there will have to be a follow-up because like there's, it's just, they're just coming in one after another. So, but I've got a number of them here that we got earlier. So we'll go ahead and finish with those. So, okay. So next up we have defendant's motion for a specific discovery. And someday, I'm trying to think of a song about someday. Anyway, someday, when Twiz is at his computer, we will have Twiz reads. I'll make it happen. Whatever it takes, guys. Whatever it takes, we will make it happen. Someday we'll have Twiz reads, Karen read, and it will be amazing. So yeah. Okay. The eve of trial, right? Okay. Files the instant motion for specific discovery pursuant to Mass ARCCA Rule 14 on the eve of trial as a housekeeping matter to ensure discovery is complete in advance of trial. Defense requests the Commonwealth produce the following materials: any contracts, agreements, records of payments, documents relative to or discussing any compensation of experts in connection with this case, Any recently discovered or previously undisclosed prior bad acts evidence of any witness that the Commonwealth intends to introduce at trial. Any information, including any oral or written statement or communication of any witness suggesting a reluctance or refusal to testify in connection with this case. That's an interesting one, isn't it? That's interesting. Any information, including any oral or written statement or communication of a witness wherein a witness suggested a reluctance or refusal to cooperate. Any information, including any oral written statement or communication of any witness, including any promises, inducements, or rewards made to any witness in this case. Any information, including any oral or written statement or communication, quid pro quo, a quid pro quo. Any information or oral or written statement, possibility of changing their testimony at trial. Any communications between the Norfolk District Attorney's Office, prosecutors, all the prosecutors. And there you go. That's basically that one. We have an affidavit in support of the defendant's motion to compel. So for the document we just read. So this is Miss Little here, and that's basically, that's all that is. There you go. Notice of reciprocal discovery regarding ARCCA witnesses. Okay. Defendant hereby submits the following notice of reciprocal discovery regarding the ARCCA witnesses, Dr. Wolf and Andrew Rentschler. Request 1. A complete statement of all opinions to be expressed by Dr. Wolf and Andrew Rentschler and the basis and reasons for each opinion. This information, yeah, I was like, they already have that, right? This information is in the possession, custody, and control of the defense and has already been produced. It can be found in the ARCCA report, voir dire testimony, and trial testimony of Dr. Wolf and Dr. Rentschler. Request 2, all notes and materials, not limited to the expert's report. Commonwealth is requesting all materials relied upon in review, even if the materials are not part of their opinion or report. All materials provided by Dr. Wolf and Dr. Rentschler were listed in ARCCA's report. The United States Attorney's Office formally authorized the defense to independently retain ARCCA and produce additional discovery to the experts for their review on March 26, 2025. That same day, the defense provided additional materials to ARCCA, including Welcher's reports. Yeah, no, I read the one earlier. So the one that preceded this, I read it earlier, where he was trying to get more discovery. And it was the same thing. It was like, turn over the discovery or they should not be allowed to testify. All materials were immediately produced to the Commonwealth in reciprocal discovery. And what was interesting in that one was there was a nugget there where he said something about how it made it seem, and I mentioned it at the time, it made it seem like perhaps the feds are not done investigating, because he said something about the ongoing investigation or ongoing subpoena that the feds have with them. And so I talked about it earlier, how I thought that was interesting because we've only ever heard from Breenan that they were done, but maybe we'll learn more here. Okay. Request 3, a copy of all materials were provided to ARCCA, Daniel Wolf, Andrew Rentschler, or any representative of the U.S. Attorney's Office. All materials provided to ARCCA by the defense have been produced in reciprocal discovery. A copy of the grand jury subpoena issued by the U.S. Attorney's Office to David Yannetti, demanding the production of all materials produced in discovery to date, as well as all relevant investigative material was produced to the Commonwealth in reciprocal discovery pursuant to that subpoena. The defense produced the discovery included in the notice of discovery 1 through 47 to the U.S. Attorney's Office. On October 22nd, 2024, the defense provided the United States Attorney's Office with discovery relating to the vehicle reconstruction for the Department of Justice's determination regarding whether to provide this information in turn to the ARCCA reports, or ARCCA experts rather. The defense's understanding is that this information was not provided to ARCCA, Dr. Wolf, and or Dr. Rentschler by the U.S. Attorney's Office. Footnote 1. A copy of the specific information produced to the U.S. Attorney's Office on October 22nd relating to the reconstruction was produced to the Commonwealth in reciprocal discovery. Based on our best, and actually, this is probably referring to that same discovery. Remember when Hank Breenan tried to make it seem like they hadn't turned anything over? I think that's what they're referencing here. Based on our best efforts and reasonable review of the files, all additional information relevant to this request was produced to the U.S. Attorney's Office by the defense was provided to the Commonwealth in the federal materials both sides received from the federal government pursuant to our mutual TUI requests in February of 2024. The defense's understanding is that the only discovery materials produced to ARCCA by the U.S. Attorney's Office were the materials listed in the ARCCA's report. Request 4, all materials provided to either witness after the conclusion of the defendant's first trial. And they said they've been produced. Describe and produce any exhibits to be used as a summary, and they're going to just say they've all been produced. Describe all compensation paid to either expert for all work done regarding this case, including case preparation, testimony, travel, trial expenses. Okay, the only funds paid to ARCCA to date is the $27,000 detailed on the invoice previously produced to the Commonwealth in reciprocal discovery. On March 26th, the defense retained ARCCA for the second trial. A copy of that retainer agreement and rate sheet was produced to the Commonwealth. Okay. Provide any contracts or agreements relative to the ARCCA dues discussing compensation. All information responsive to this request has been produced. Provide all written communications, including emails and text messages between any member of the defense team and employees of ARCCA. It's been produced. Provide all copies of testing not previously disclosed, including crash test videos, or crash test video reenactments, testing materials. All information in the possession, custody, and control of the defense has been produced. And then remember when I read that document earlier, I was like, part of the challenge there was Breenan was like, for some of the stuff, right? It's like the defense doesn't have it. The feds might have it, right? But he's like, if we don't get it, they shouldn't testify, right? So I'm mentioning that because again, they're saying it's in the control of the defense. Now that's why that's just totally unreasonable, Breenan, right? Because that's all they can do. So if it's in the control of the defense, it's been produced. To the extent additional testing is conducted in furtherance of rebutting the testing conducted by Aperture LLC, that information will be produced forthwith. Provide all written communications, including emails and text messages between the United States Attorney's Office and employees of ARCCA. All information in the possession, custody, and control of the defense has been produced. Request 12, provide all communications between the U.S. Attorney's Office and any member of the defense team as it pertains to the expert testimony in this case, including dates and substance of phone calls, copies of any written correspondence, dates of any strategy meetings, and list all materials received from the United States Attorney's Office. All communications have been produced. The TUI materials received by the defense have been produced. Number 13, provide a copy of all written requests that have been made by the defense team pursuant to the TUI regulations relative to either expert or ARCCA. And also all TUI requests have been produced. So see what happens there. Next up, Commonwealth's motion to eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate. Oh, so this is the one that's the big one. So we don't have her formal ruling yet, but this just came out. So the point here, the reason we have this is because of what it says on the bottom. So this is her making a note on there, and then there will be a subsequent order, right? It's denied. So this is in other words, the Commonwealth asked them to redact the manner of death, right? And that is denied. The medical examiner will be testifying and can be examined on this case. Now, what's interesting is they said she wasn't going to be testifying. So I wonder, this is interesting. I wonder if she means by the defense. Because she's on the defense's witness list and they can call her. But she can't force the Commonwealth to call her, right? Although it's crazy if they didn't. But anyway, so that's what it says. Denied. The medical examiner will be testifying and can be examined on this, I think it's his case, on this, whatever that is. Issue, maybe. Her handwriting. Yeah, issue, maybe it says. Okay. And I do believe that is the last one that I already have. Yes, it is. Right. She's on both witness lists, right? But we covered this in the hearing. They said they're not calling her. That's what they said. I think we even went back and watched it. She's on both witness lists, right? But they don't have to call everybody on the witness list. Like, do you think they're really going to call Turtle Boy? You know what I mean? Like, she's on both witness lists, but they said they're not calling her. And it's because they said they're not calling her that Miss Little made the mistake thinking she wasn't on the witness list. And then they said, yes, she is on the witness list, but we're not calling her. Right. So, but this was dated today or yesterday, Judge Bev. So at this point, what Judge Bev knows is what we know, right? Well, she knows more, but what I mean is that she wrote this note at the bottom after the Commonwealth already said they weren't calling her. So that's why I'm saying I wonder if what she means here is she will be testifying because of the defense, right? Because in other words, if it's strong languaging, right? Because technically nobody has to call her, right? Even if the defense says even if she's on the witness list for, she's on the witness list for both sides, right? Neither side I mean, again, it's crazy that no one would. I'm not saying they wouldn't, but just theoretically, neither side, like as a judge, right? She can't say will be as in it's an order, right? Like that's what I mean is like, she can't order a witness to testify, unless it's like they're being called and they're not responding to a subpoena. But what I mean is to be called, right? So to say will be testifying is very strong language, because technically neither side has to call her. So if that makes sense. Again, there's no reason the defense wouldn't call her if the Commonwealth doesn't, or even if they do, they could still call her again. But technically, just for the sake of theoretically, like neither side could call her, right? There's witnesses on the list, on that witness list that are on the list for both sides that I'm sure neither side will call. So, it's interesting. It's just such strong language. Yeah, perhaps. But who knows? She might flesh that out whenever she makes her actual ruling on this. So I mean, there's even more filings that are coming out. It's just hard to, it was amazing I was able to get any of these while live streaming. I had to use my phone. But what I'll do is we'll have to do another follow-up with whatever the next batch of documents are. So that way I can get all that organized and whatnot. Yeah. So I think what we'll have later is I'll have to just see how much comes out, right? Because if a lot comes out for either this, and then again, if there's more for Idaho too, it could be. I mean, we still haven't finished. We're not even caught up on that with the newest onslaught. But basically, there's any possibility of what we will be streaming and when, because there's so many different things. But on, in the near future, right? We'll see what's going to happen later today. But in the near future, right, we will definitely have another Karen Reed. We'll obviously have another Idaho. And we will do the Shanna Gardner hearing. And of course, we will also have another Murdoch here soon too. Yeah, that was, remember when we were listening to the robot read the Vanity Fair article? That was that. Right. But they don't have to, right? They don't have to. That's my point, is that they have the right to not call, they have the right to not call her, right? So it's just such strong languaging because it makes it sound like it's an order. Just legally speaking, right? That sounds like an order, but she can't order anybody to call her. So yeah, it was in the robot was reading it, but yeah, she joined Unetti's firm, and she is going to be part of it. There's already been a notice of appearance or whatever. Like we don't have a document yet, but it's on the docket that it will be out. It might even come out today, that we can actually read. But yeah, it's a real thing. It's a real thing. But so far, we just have that article from Vanity Fair. Well, we heard the robot read it. But that'll be it for this one. So we will be back later with more things. And right now, actually, I may pop on over to SDS because I think they have they're doing the Wendy Adelson interrogation in chunks and breaking it down with like detectives and stuff. And I'm not always able to be there live. I might pop in for a few minutes and watch some of that because you guys know why. I mean, it's just too good. It's just too good to miss. But yes, you're very welcome. Love you guys. We will be back later for more, and maybe, fingers crossed, we'll be able to get Twiz on if he's not being lame. He maybe fell asleep. Maybe he wasn't kidding, and maybe he fell asleep. If he's still listening, Twiz, don't be lame. But I will see you guys later. Love y'all, and squirrel out.